Number 1, learned counsel for the respondent number 1 submits that certain errors crept in the judgment dated May 1, 2025, passed in FMAT 42 of 2025 with CAN 1 of 2025. Full stop. Next para. Learned counsel appearing for the appellant submits that in principle, he does not have any objection to the other corrections than the corrections intended to paragraphs 46 and 56 of the said judgment. Full stop. Upon a perusal of the corrections in paragraphs 46 and 56, which are sought by the respondent number 1 now, we find that there might be some substance in the contention of the appellant that those relate to the merits of the case. Full stop. Even if there was an error in the order to that effect, the same cannot be corrected by mere verbal mentioning. Full stop. Inasmuch as the submission recorded to have been made by defendant numbers 1 to 5, which now is sought to be argued to have been made by defendant number 2 only, since the judgment was passed some time back, we do not exactly recollect what transpired in court, and as such, we do not intend to carry out such correction, since it apparently reflects the happenings which happened in court on the said date. Full stop. It may be recorded here that learned counsel for the respondent number 18 also seeks a similar correction as respondent number 1 in paragraph number 46, which has been dealt with above. Full stop. Next para. However, regarding the other corrections sought, we find that those are innocuous in nature and may be corrected. Full stop. Accordingly, the following corrections may be deemed to stand incorporated in the judgment dated May 1, 2025, (দিয়ে তারপর 1, 2, 3, 4 করে দাও. In paragraph number 3 of the judgment, the name of Bishwanath, Bishwanath, double inverted mode, was erroneously printed as double inverted mode Biwanath, double inverted close, full stop. Next, number 2 arki.
Paragraph number 8, my lords.
In paragraph number 8, in the second line, the year 2023 was erroneously printed as 2003. Full stop. In the fifth line of the said paragraph, instead of petitioners, double inverted mode, it should be read as double inverted respondent number 1. Full stop. Next para. In paragraph number next para, same para. In paragraph number 9, next para. In paragraph number 9 of the judgment, within parenthesis, the year of title suit number 423 should be read as 2023 instead of 2003. Full stop. Next para kore dao.
Paragraph 19, my lords.
Page 7. In paragraph number 19, in the first line, instead of double inverted primary defendant, double inverted close, it should be read as plaintiff. Full stop. In the third line from the bottom of the self-same paragraph, the word plaintiffs, double inverted in plural, should be replaced by the singular double inverted plaintiff. Next para.
Paragraph 58, my lords. Page 21, my lord, paragraph 58.
In paragraph 58, in the last line, the expression double inverted the plaintiff stroke appellant shall be read as plaintiff stroke respondent number 1. Next, page 23. 23, yes. In the first line of paragraph number 62, the word appellant shall be read as respondent number 1. Last chapter kore dao. In paragraph number 69, the expression double inverted senior judge should be read as civil judge. Full stop. Next para. Let the above corrections be deemed to stand incorporated in the judgment dated May 1, 2025. Full stop. Next para. Nothing in this order shall preclude the parties from taking out an appropriate application for review stroke for review in the event the parties are of the opinion that certain other errors apparent on the face of the record remain in the order.
So,
I beg to differ the respondent, my lord.
Yes, Mr. Rajab.
My lord, this
You
matter.
mentioned. Huh?
We have not mentioned the matter, my lord.
Oh, we had erroneously recorded that a formal decree be drawn up. In probate proceedings, it's not done.
My lord, I have found a true correction that is
No,
required.
no, no.
My lord, it's not factual correction, my lord. In paragraph 1, my lord has mentioned that the property to her eldest daughter, Shashwati is the middle daughter, my lord.
Let those remain.
And in another paragraph, my lord has mentioned the testatrix as PW1.
The?
Testatrix as PW1. My lord, paragraph 57, my lord.
That is serious.
It was my lord's finding only. My lord, the PW1, despite being a housewife having no income of her own, as alleged by the appellant, was looking after the partition by herself all the time. It will be the testatrix being testatrix, my lord.
Yes, yes. Absolutely. Yes. Ms. Ojas, he is correct.
Yes, ma'am.
Cannot be the PW1, it has to be the testatrix. And then what is the first?
And my lord, in the paragraph 1,
Yes.
it was written that by virtue of the said will, the testatrix left her Kolkata property to her eldest daughter Shashwati.
Middle.
Is the middle daughter Shashwati, my lord. The appellant is the eldest daughter.
Right. The learned counsel for the respondents points out that in paragraph number 1 of the judgment dated May 13, 2025, comma, the middle daughter Shashwati was erroneously mentioned as eldest daughter. Full stop. Also, comma, in paragraph number 28 of the said judgment, sorry, in paragraph number 57 of the said judgment, comma, in the first line, comma, instead of double inverted the PW1 double inverted close, comma, it should be read as double inverted মধ্যে testatrix double inverted close full stop. Next para, further, comma, in the last paragraph we had erroneously directed that a formal decree be drawn up full stop. Since the matter arises out of a testamentary proceeding, comma, there is no scope of drawing up of a decree and the said sentence should be deemed to stand deleted.
Grateful, lord. Thank you.
আর ডিগ্রি ডাউন আপ করতে হবে না। Yes. Yes, Mr. Vandal.
I am for the respondent.
Right.
Respondent dependent.
You are for the KMDA.
KMD.
State is separately represented. State is a party here. Anyway, KMD is the main contesting this one. Ask for it.
But the state is not a party also.
State is not a party, right?
One defendant will.
Yes, yes. No, and others it's written at the top. Anyway, KMD is the main party.
To be near.
KMDA,
Be near the-
chairman KMDA and special secretary.
All KMDA people. Yes.
I am defending in order. So, my lord, the crux of the argument, my lord, if I have understood, is that, my lord, first of all, though there was a time period making construction,
Yes.
and though the plaintiff had failed to adhere to that timeline to even start the construction, but they say the crux of the argument is that the fault lies with the KMDA. And because of KMDA, mainly because of the faulty title of the KMDA,
Yes.
the work could not be started. Well, I'll show the license deed that they did not require to only start, but they required to complete also. I'll show it from the language. My lord. Your lordship must have noted it already. Now, my lord, the other argument, major argument, is that the license deed is in effect a lease deed. Now, my lord, for this, there are two arguments I'll make. One is on the law and also deal with the judgments, my lord. The second is that, interestingly, this was never the case before the trial court. This was neither the plaint case, nor does this appear as such in the my lord, evidence, nor, my lord, it was argued before the trial judge. Now, my lord, your lordship sees the impugned order once, before I take your lordship through the other papers. My lord, issues 1 and 2 perhaps will not be much relevant. So both have been answered in favor of the plaintiff regarding the maintainability.
Yes.
Your lordship kindly takes internal page 20 of the
20.
where the heading issues number 3, 4, and 5.
Yes. Page 267, part 1.
These issues being related taken up together, it is the specific case of the plaintiff whereby the plaintiff has challenged the refund advice dated 1st February 2008, purported threat of cancellation of allotment made in favor of the plaintiff, with an order dated 8 January 2008, purported to have been communicated to the plaintiff under cover letter of so and posted on so and served upon the plaintiff on so. The entire prayer of the plaint rests on holding a declaration valid with a order of allotment dated 6th March 2003 and 7th March 2003, which if fails, the entire suit would fail, as well as the order dated 8th January 2008 would follow. 8th January 2008 is the termination of the license. After going through the allotment letters dated 6th March 2003 and 7th March 2003, which merely lay down the enumerations of payment liable to be made by the plaintiff, it becomes necessary to refer to the deed of license dated 22nd May 2003. On perusal of the deed of license dated 22nd May 2003, executed by and between the Calcutta Metropolitan Development Authority and Messrs. Haldiram, then page 2 is quoted, and whereas the authority is not now in a position to grant any lease or of the after mentioned land in favor of the licensee, then para 2, license under this deed shall be deemed to commence on the date of this presence and shall continue to be operative till the execution and registration of a deed of lease in respect of so and so license or till expiry of a period of 99 years, whichever event occurs earlier. Then page 3, para 5, Roman 3, at the own cost of the license within 3 years. It is not entirely quoted, so I'll place it anyway. But kindly skips over the quotation. Kindly take the bottom 2 lines. After going through the contentions of the plaintiff and the defendant, it becomes clear that the entire cause of action relies on the deed of license and its essence with regard to time and purpose. While plaintiff alleges his right to enjoy the property on the basis of allotments made through the letters dated 6th March 2003 and 7th March 2003, at the same time seeks invalidation of the order terminating the license, defendant states through his evidence and contractual obligation under the deed of license that the plaintiff was bound by the condition of the deed of license, which makes construction and completion of the supermarket cum food processing unit within 3 years sine qua non, that is paragraph 5.3 of the license deed. Further relying on para 5 Roman 8 of the license deed, which necessitates construction of supermarket cum food processing unit, the plaintiff failed to convince the reason of inordinate delay. Then application of NOC dated 10th March 2006 to the West Bengal Pollution Control Board since the conclusion of the deed of license. In making the construction, in fact, I'll just pause here for a moment. In fact, not only Pollution Control Board, even the fire license, though they knew that it is necessary for their purpose, this was also applied much later toward the fag end when the time period was about to end. In making construction within the time for the said purpose, whereas the defendant contended that the said land is being used as a godown by the plaintiff in contravention of the contract entered upon. The plaintiff has also made out that he should be permitted to enjoy the license for 99 years reasonably and legitimately as promised by the defendant authority. It is true that the deed of license contains the clauses that make the license operative until registration of the deed of license or 99 years of license, as well as clause 7(4) of the license deed reiterate that upon completion of the process of acquisition of land in favor of West Bengal government, the latter shall accept the lease of the said land. However, the question of the license being operative for either 99 years or being converted into a lease subject to acquisition does not arise at all, as the contract entered into bears clear clause of termination which has been put into effect. So, it was determinable. The order issued vide number so and so of 1st February 2008 by KMDA indeed has discrepancies pertaining to the date of assent and dispatch, but the contention contained in the order cannot be disputed, and hence the same being valid, the plaintiff is a defaulter with regard to the terms of the agreement, where time is the essence of the contract. Keeping in view the socio-economic so and so, that is that. Therefore,
Give us half a. Yes.
So, my lord, the finding that the time was the essence of the contract. And, my lord, here I must point out, and, my lord, this I'll come back to this, my lord, at the end when I distinguish the judgments, that in this case, no extension was ever paid from me. No extension was thus given by me. Therefore, there was no question of enlarging the time and thereafter putting the any person on notice that again time is the essence. That situation did not arise. Only one argument can be made that immediately after the 3 years ended, you did not give the show cause immediately thereafter. There, my lord, I'll show a document where I had asked for that you please show me the building plan at least, which is after the letter, thereafter the show cause, and thereafter the termination followed.
Yes.
My lord, yes, my lord, what is to be pointed out is that the extension, if any, at our discretion, that situation did not come because there was no application at all. Now, my lord, if your lordship takes, my lord, if your lordship takes the volume 2,
Yes.
page 3.
Yes. Pastry.
Well, this is the booklet.
Right.
Kindly give me a moment. From which, my lord, my learned friend has shown. Your lordship kindly takes page 4.
Yes. Yes.
But kindly takes 1, 3, 7, and 8. So the plot will be offered on leasehold basis to the highest bidder for a period of 99 years with an option of renewal of like period subject to the mutual consent of the lessor and lessee. The 3, offer with an precondition is liable for rejection. 7, that the land of the building constructed thereon must be used for institutional commercial purpose like school, college, research, office building, hotel, multiplex, and entertainment center. Then 8, construction on the plot has to be completed within a period of 3 years from the date of execution of the lease deed according to the approval plan of Kolkata Municipal Corporation. Failing with the allotee will be liable for compensation as decided by the authority, I believe. Then, my lord, 11. Well, these are the clauses which has been relied upon by my learned senior friend, my lord. But their emphasis is that this will ultimately be binding in spite of the fact that subsequently a license deed has been executed by both the parties. And, my lord, still, my lord, the pre-contractual conduct is to be seen. My lord, here my arguments will be, while placing the license deed, my lord, there is no such ambiguity in the license deed for which the pre-contractual conduct has to be resorted to by your lordships to understand that what meaning the parties wanted to give to the clauses of the license deed. Page 8. Then, my lord, kindly takes page 10. But this is KMDA's offer for allotment of bulk land. Okay, for allotment of the
Yes.
This is to inform, my lord, your lordship has page 10, my lord.
Yes.
This is to inform you that the competent authority of KMDA has accepted your sealed bid submitted on so and willing to offer you an allotment of land measuring more or less 122 kathas bearing so at the rate of only per katha on license basis. In terms of your application dated 11th February 2003 for establishment of 11 February is at page 8, page 7 for your lordship's convenience.
Yes.
For establishment of supermarket cum food processing unit along with residential facility for company management and staff only, compatible with the project report submitted by you with a letter dated so and subject to necessary statutory clearances and clearance from West Bengal State Pollution Control Board. So you are requested to depositing of the amount. 14. Next is their acceptance at page 14.
Yes.
Our last letter was 18 February. Acceptance of offer for allotment of bound. We are in receipt of your letter dated 18 February 2003 and thanking you for offering us the allotment of bulk land in East Kolkata Township with a right to sublease the plot as assured verbally by the Special Secretary during the meeting of and same will be mentioned in the license deed. Later automatically converted into lease deed after clearance of the right from the LA department by KMD. We hereby accept your offer for allotment of bulk land and for the term of your aforesaid offer, we are enclosing here a banker's check of so towards security money total premium so. Further, we would like to inform you that we want to avail so rebate. Then, my lord, the allotment is at in the supplementary paper book, the single page. Soft copy আছে। পাচ্ছি না, বাজছিল একটু আগে, রাখ ওটা। কেউ ওকে দিয়ে দেবো, বেরোতে পারবে, ওর কাছে থাক, ওর there is a supplement.
Yes, yes, we have got it.
But few relevant clauses, if your lordship takes,
Yes.
at page 1. In reference to the above letter, this is to inform you, and I'm reading from the beginning.
Yes.
This is to inform you that a plot of bulk land measuring so and so was offered to you by the competent authority in KMDA for establishment of supermarket cum food processing unit along with residential facility for company management and staff. Now, in view of your acceptance of the above offer on the subsequent deposit of 10% of the total premium amount to so and so as security deposit, the plot measuring so and so as per the site plan in plot number so and so is hereby allotted in favor of your company at rupees 6,60,000 per kata at a total premium of 8 crores 4 lakhs. Only as per the terms and conditions enclosed herewith. Then the terms and condition, my lord, kindly turns over to the next page. Kindly take serial number 2.
Yes.
The license shall be allotted on license basis for 99 years. For the present, license deed will be converted into lease deed in due course. Then kindly turns over page 3, towards the bottom, Roman 5A.
Hmm.
The land shall be allotted on license basis for a period of 99 years. For the present, license deed will be converted into lease deed in due course. Then kindly comes to page 5. Sorry, page 5. Page 5. Last clause. The terms and conditions as mentioned above are not exhaustive. The allottee, after fulfillment of the terms and conditions above, will have to execute and register a lease deed which shall contain a detailed terms and conditions of the demise in due course. So, the terms of the allotment is not exhaustive, and lease deed will be preceded by fulfillment of the terms and conditions above.
The 3-month period is there above.
Construction.
Construction, it's not there.
So construction is there in the lease deed. License deed, I'm sorry.
Ah.
License deed. Then, my lord, at page 19, though I'm not placing it, they were asked to pay the amount of premium.
Hmm.
Now, my lord, will 19 is, my lord, we had called them for the payment of the premium, which is admittedly paid, and admittedly we tried to return also. My lord, 20,
Different name.
not admitted. We tried. I said we tried to return. My trying, please don't deny my trying. Supplementary. But in 20 is an objection they have raised. Only one objection is there regarding the allotment, that you have allotted us a aforesaid plot for the purpose of establishing supermarket so and so. We draw your kind attention on para 10H of the aforesaid allotment letter, which is contradictory to the object of the project. We mentioned here under that the detailing of para for your ready reference. The allotment shall not transfer possession of land and or structure erected thereon, and shall not transfer any interest ever such land and or structure thereon to any person without the previous permission of the authority in writing. In case of such unauthorized transfer, the allotment shall stand cancelled and the property would revert to the CMDA, which shall have the right of re-entry into the land. Sir, on the one hand, you are allotting us a land for the purpose of establishing supermarket, but on the other hand, you are restricting us to transfer or sublease the land and or structure thereon which is prejudicial to the object of the project. We would also like to refer to our letter dated 20th February 2003, wherein we have accepted your offer letter only after verbal commitment of allowing us to sublease the plot of land or structure thereon from all related senior officers. In this one. So therefore, my lord, their only objection was with regard to 10H. I'm not reading 10H because it's quoted here. And for the other parts of the letter of allotment, they had no objection. Then, my lord, the payment is made. Then kindly take একটা ডেটটা তো এটা আবার এখানে নেই তো এই 25শে মার্চ 2003 হ্যাঁ নেই my lord, I'll give you a lordship's a date, my lord. I'll give the page, my lord, in due course, my lord. My lord, on 25th March 2003, the plaintiff applied for mutation to the KMC.
Since
Now, my lord, in the meantime, I can show a few documents, but my lord, I am rather reluctant to show. My lord, there was a dispute with regard to, my lord, the possession of the land, some encumbrances, some disturbances in the land, which all preceded the license deed. My lord, I can give the reference of these documents. These are at paper book, page 34, where they approach the police authorities. I am not placing it because it is more for my learned friend, senior friend to place those documents. And there was an order of status quo which they informed at page 36. These are all part of their allegation against me. But my lord, ultimately the vacant possession was handed over to them on 29th of April 2003, which is at page 38. So 34 and 36 I am not placing, because those documents, my lord, though they are relied on, they will ultimately not cause any effect on the time which they were given, because their time runs from the date of the license deed. And these page 34, 36 all precede the license deed. Malab, the handing over of possession, page 38, is on 29th of April 2003.
Yes.
Malab, next is the license deed, which is at page 40. I will kindly take internal page 2.
Yes.
Page 41.
Yes.
Second paragraph. The authority is not now in a position to grant any lease of the after mentioned land in favor of the licensee. And whereas to enable the licensee to construct the supermarket cum food processing unit along with residential facility, the company management and staff and authority has agreed to grant a license in favor of the licensee for the time being on the terms and conditions appearing hereinafter appearing. Then 1 and 2, in consideration of sum of 7 crores 64 lakhs only paid by the licensee, this will be licensee to the authority before the execution of the presents, and in consideration of the annual license fee and licensee's covenants hereinafter reserved and contained, the authority hereby license and authorize the licensee to enter upon the land hereinafter mentioned and more particularly described in the schedule hereinafter written, and to use and occupy the same strictly for the purpose mentioned hereinafter. Therefore, the permission to entry is strictly for the purpose which is mentioned here. That exclusive right which is comes with the lease is not there. That will be my argument for stressing on this clause. Then point number 2, clause number 2, the license under this deed shall be deemed to commence on the date of these presents and shall continue to be operative till execution and registration of the deed of license in respect of the above mentioned land between the authority and the licensee, or till expiry of period of 99 years from the date of its commencement, whichever event occurs earlier. Then kindly page 42.
Yes.
5 Roman 3.
Licensee's
covenant 5 Roman 3. At the own cost of the licensee within 3 years from the date hereof, or within such further time as the authority may as its option allow, in writing on sufficient and reasonable grounds, to erect, construct and complete the proposed supermarket cum food processing unit along with residential facility for company management and staff with boundary walls, sewers, drains in accordance with plans, sections and specifications as shall be approved by the appropriate authorities on payment of such fees as required in accordance with the building rules of the Kolkata Municipal Corporation, with the requirement of any land use and development control regulations of the authority or the requirement of any statutory rules and regulations of this local statutory body framed for this purpose. Then Roman 6, not to subdivide and or sublet the land or any building to be constructed thereon without the previous consent in writing of the authority, which consent the authority shall have the right to be entitled to refuse at its absolute discretion. Then 43. Roman 7, not to assign or transfer or the land or any part thereof or any structure or constitution erected thereon or any part thereof without the previous permission of the authority in writing. In case of such transfer or assignment of the land or structure, the construction thereon, without such permission of the authority, license shall stand terminated. Then Roman 8, not to use or allow to be used the land or any structure erected thereon or part thereof for any purpose other than the purpose of supermarket cum food processing unit, along with residential facility for company management and staff without previous consent of the authority. Then kindly takes page 44. 6.1. The licensee observing and fulfilling all terms and conditions on its part contained therein, herein, and paying the license fee hereby reserved, shall hold and enjoy the land during the period of this license without any interruption by the authority or any other person acting on behalf of the authority. So, my lord, kindly mark the word fulfilling all terms and conditions on its part contained herein, which my lord, will include that 3 years for construction of the building. Then 7.1 and 7.4. If there be any breach of any covenant of the licensee's part herein contained and to be performed or observed by the licensee, it shall be lawful for the authority at any time to re-enter upon the land after determining the license. Then Roman 4. Upon completion of process of acquisition of the land hereby licensed and the transfer of the title of the said land in favor of the authority by the government of the state of West Bengal, the authority shall grant and the licensee shall accept a lease of the said land described in the schedule herein under written for a period of 99 years, commencing from the day, month, and year above written on the terms and conditions and on such other terms as well. Only after the process is completed by the state government, thereafter the question of lease will follow. And this has also been made clear in the second page of the license, where there cannot be any confusion that it was not known to them that still the process is not complete and therefore it cannot be granted. The lease cannot be granted. One more clause, my lord, I might require it later, my lord. 7 Roman 3 at page 44. That any relaxation or indulgence by the authority to the licensee or by the licensee to the authority shall not in any way prejudice the rights of the parties under this lease deed of license. Therefore, my lord, it goes both ways. Any indulgence granted or relaxation, direct or indirect.
You're not terminating it even after 3 months. You're
3 years.
3 years. You're not terminating even after 3 years.
If
That
it is
may be-
taken as a relaxation or indulgence, but both words probably was not required because it ultimately means the same thing in this context.
Not necessarily. Indulgence is you sit tight over the matter, do nothing. And relaxation is a positive act.
Active act. It is rather in this case, it's a indulgence which has been
yes.
given.
You indulge.
Rather a relaxation. But it is both ways. It is not a clause which is only for my benefit, which has been put and not to prejudice the licensee to that effect. So these are the vital clauses of the license. Now, my lord, your lordship will take page 47. My lord, this is dated 22nd May 2003.
Yes.
So our reference point will be 21st May 2006. Now, my lord, the trade license is granted to them at page 47. That is dated 28th of July 2003. Next, my lord, your lordship will kindly take, after 47, your lordship will kindly take 74. My lord, in this time period, another issue arose with regard to payment of municipal taxes. And according to them, up to a particular period, KMDA was supposed to pay the taxes, and after that period, they were supposed to pay the taxes. And they required us to make this matter clear with the KMC. That letter, my lord, which has been made to us is at 73, but at 7, kindly take 74, where we have written to KMC that, and this is dated 18th December 2003, that in reference to the above matters, so and so SSC number I am directed to inform you that the land which is allotted to Haldiram, who is liable to pay municipal taxes from the date of getting possession of the land taken over from KMDA, and prior to that, KMDA is liable to pay municipal taxes of the said land to KMC. So, as was required from us, we have cleared the matter with the KMC so that there is no hindrance as far as the Haldiram is concerned in going about their responsibilities. Next, my lord, your lordship, my lord, I'll trouble your lordship with the volume 1 once.
There was no provision in the license deed regarding payment of tax. Doesn't appear to be so.
Yes.
There was.
Yes, I'll indicate the clause. My lord, if your lordship kindly takes internal page 3 of the
Yes.
license.
See.
Yes. The 5.2.
Yes.
Pay all rent, taxes, and other impositions in respect of the aforementioned land and structures to be erected thereon, which are may be assessed to be liable to be paid by the owner occupier thereof during the term of the license.
Right.
During the term of the license, which we have given a letter saying that from the date of possession, after possession, they will pay. However, ultimately, I am rushing through these documents because ultimately these documents, in my humble understanding, may not, volume 1, page 49. Kindly gives me 1 minute. Yes. Yes. But kindly, my lord, takes. সেটা হয় তাহলে ওই জায়গাটা ফ্লুইড হয়ে যাচ্ছে সিএসটা অতটা ডাইরেক্ট হয়ে যাচ্ছে না এক্স্যাক্টলি স্কোপ আছে প্ল্যান না করে এটা যদি অ্যাপ্লাই না করে কমার্শিয়াল ঠিক ঠিক প্লাস কোড এসব কিছু
Sorry. Yes.
But I'll trouble your lordship with the volume 1 once.
Yes.
Because this date comes in the middle. Where page 29, para 49. This is part of the plaint. Para 49 of the plaint.
Yes. Para 49. Oh, acha. There are 3 sets of paginations.
Page 29.
Yes.
First paragraph in that page.
Right.
After mutation of the name in the record of KMC on so and so, the plaintiff applied for sanction building plan before the municipal authority. Therefore, my lord, this application for sanction was sometime after 28 December 2004. The earliest time is 28 December 2004. This is the date which has to be discerned from the plaint. Then, my lord, I'm giving, I'm not placing the documents, but ঠিক আছে আমি ওগুলো দেখাচ্ছি Malad, few documents
Hmm.
which I'm referring to but not showing to your lordship, Malad. Malad, they wanted us to give the site plan.
Hmm.
They required us to give the site plan on 29th November 2004. That is page 90, volume 2. Which detailed layout plan we have given to them on 17 December 2004.
You said page 19
90
of part
of
2.
volume 2.
Yes.
But documents are all only that
Yes,
for that
obvious.
one document, Malad, I showed volume 1.
Right.
Detailed layout plan we have given to them on 17 December 2004. That is page 91 of volume 2. Malad, 10 December 2004,
Yes.
Government of India has given them explosive license at page 92. HPCL allowed them to install bulk LPG storage system on 31st December 2004. That is page 94 to 104 of volume 2. And CSC granted them connection and এই ডেটটা এই পাতাটা তো নেই commercial connection was granted on 17 February 2005. এতে তো ছিল এই পাতাটা বার করে দাও এর 140 17 February 2005. Now, Malad, a very vital document kindly takes page 111 of volume 2.
Yes.
Malad, this is the KMC Building Committee's resolutions of sort. And this is dated 28th February 2008. 2005, I'm sorry, 2005. একটা 23/2 এর কাগজে দেখো এই রাজা I'm placing it, Malad, 111.
Yes.
The plan case has been examined by the Municipal Building Committee meeting. Considering the provisions of the ramp, the committee recommends for relaxation of ground coverage of the proposed ramp leading from ground to plinth level and the ground floor to top floor, considering that the provision of such ramp is for handicapped worker. The plan case is recommended for sanction subject to compliance of other departmental requisitions, if any. Necessary clearances concerned from Traffic Department, West Bengal Fire Service and microwave clearances from the respective department will be required. According to the requisition of CSC, high tension supply is required. Therefore, my lord, your lordship will not find a whisper of discussion regarding my title. It is not saying that sanction will not be given to them because KMDS title is not clear. This was the crux of the argument, that I could not construct because KMDS title was not clear. Therefore, KMC had recommended sanction of the plan. If there be any delay, any latches, etc., on the part of KMC in granting the sanction plan, if that is their case, first of all, it cannot be put on my shoulders, and secondly, their remedy is elsewhere. Their remedy is not against me. Stay তে ছিল তো কাগজটা, stay তে 195 আছে। আমাদের পেপার বুকে 23/2/2005 নেই, 23/2/2005
क्या कि भाई
এই ডকুমেন্টটা, এই ডকুমেন্ট স্টে তে ছিল।
এটা কোন এক্সিবিট আছে
কেএমসি আছে, স্টে তে আছে।
रोज एक मिनट
हाँ?
देखते हैं
ঠিক আছে, ঠিক আছে। Then my lord kindly sees page 120. And kindly mark the date. That is, this is on 17th February 2006. And two things. One is at the fag end of this 3 years period, this application is being made, which has also been noticed by the trial judge. And number two is that this committee meeting of KMC required them when this required them to apply for this NOC. This I showed on 28th February 2005. Your lordship will remember at 111 in the last line it was written this NOC is required.
Subject to.
This they are applying, my lord, after 1 year. Committee meeting was 28th February 2005 and they have applied for the Pollution Control Board on 17th February 2006. Then, my lord, the time expires. This 31st May 2006, 21st May 2006, the time expires. Then immediately thereafter, my lord, we write a letter to them at page 126.
ওটা নেই
নেই না?
ট্রায়াল কোর্টের এক্সিবিটেড লিস্ট আছে
তাই নেই, সেই জন্য ওখানে আসেনি।
Yes.
126. On 31st May 2006, we write to them that I am directed to request you to submit an attested copy of the building plan approved by KMC proposed to be constructed on plot C5 under EKDP covering entire 122 katas. After this, after we give this letter at 127, they give us a letter. That please note that you have leased to us plot of land being premises number so and so. We now wish to start construction of the above site. You are therefore requested to kindly issue us necessary NOC. Hope you will kindly issue NOC at an early date so that we can start our construction work. But nothing turns from this letter. There is no purpose of this letter.
No NOC was required.
First of all, no NOC was required. Secondly, there is no building plan at all. Therefore, the question of construction does not arise. If they could construct without a building plan, assuming, and NOC was required, they could have asked for it on 23rd May 2003. If it can be done without building plan, if it is not related to building plan, why wait for the term to be over, then ask for a NOC from me? I have given you the plot of land, permission to enter on the plot of land. For this only purpose is to construct. The license deed, the terms of the license deed is that I cannot give you a lease deed right now. Let us not waste the time. You start the construction because the land should be utilized, which is that penultimate paragraph of the trial court judgment, which I did not read. Your lordship will remember, my learned senior friend had read it, that the socio-economic need of utilization of the land, etc.
Yes.
Now, my lord, page 128. That earlier letter is 3rd June 2006. Now 128 is 20th November 2007. We are 1.5 years down the line. We have submitted building plan along with relative papers for approval of the building construction plan. We therefore request you to let us know about the status. So no building plan as on date, even after 1.5 years. And they are asking for NOC just to fill up the gap. However, this is the time where our indulgence came in, my lord. Then, my lord, 137 is the show cause. 31st December 2007.
Yeah.
A plot of land measuring so and so in so and so in this was allotted to you, and subsequently a license deed was executed on May 22, 2003 for construction of supermarket cum food processing unit. However, it appears that you have not taken any steps for construction of the project. I hereby give you notice that the deed of license dated May 22, 2003 between KMDA of one part and you on the other part contain inter alia the following covenants to the observed and performed on your part, being 5 Roman 3, which is construction, and 5 Roman 8. The said license deed also provide for cancellation of the license deed and consequential right of re-entry in the said property on violation inter alia of any such covenants. As you have violated the covenants of the license deed as specifically mentioned above, I hereby give you notice to appear before the undersigned on January 8, 2008 at 11 a.m. to explain the reasons why the license deed could not be followed and why KMDA should not cancel the allotment and thereafter re-enter upon the land as per the provisions of 7(1) of the license deed. Now, my lord, this is followed by a hearing on 8. Well, this was followed by a hearing, supposed hearing on 8 January 2008, where they had given a written reply to the show cause. And also, PW2 has claimed that he visited the office, but no appropriate hearing was given to him. That I'll show from PW2's hearing after the documents. This is their reply. Kindly takes page 139. We have applied for mutation of the land, but till date not received the mutation certificate. In reason, KMC verbally told that the land title is not clear and we can't issue the mutation certificate. We have submitted several reminders on so and so, but we have not received any reply from their end. We have paid the municipal property tax as per Xerox copy so and so. We have obtained the approval from the Department of Explosives on 12 December 2004. We have submitted the application to the Office of the West Bengal Pollution Control Board on 10th March 2006, along with a license fee so and so. Thereafter, WPCB inspection of site on 11 September 2006, and we are still awaiting their reply. We have submitted the application in the Office of the Government of West Bengal, Department of Fire Service. They have issued demand notice on 7th June 2005. We have deposited the amount on 26th of July 2005. We have submitted project construction plan along with papers to the Kolkata Municipal Corporation for sanction of the same, but department is still under scrutiny of the papers. We have submitted a letter to your office addressed to Deputy Secretary on 5th October 2005 for actual status of the land and requested to clarify the KMC assessment and building department respectively, but not reply from your end. We very much interested to start the project immediately. We therefore request you to please allow us to start the work as soon as we receive the approval from the appropriate authorities. We also request you to please convert the license deed to registered lease deed to solve the requirement of appropriate related authorities to sanction of the building plan. But none of the documents will show that any authority required them to place a license deed to give the permission. Nor is it borne out of any of the documents.
Only this verbally told.
Only that verbal requirement by KMC, but the other documents which are also part of the exhibit, none will show that the authority got back to them saying that you show a license deed, thereafter I'll give you NOC, or I'll give you exclusive license, or I'll give you bulk LPG license, etc., etc.
But the other applications they had made in reasonable time, fire, pollution, not pollution, fire, explosive and all. Pollution they've applied 1 year after even the
Fire and pollution. They have
fire.
the fag end.
Fire they say page 139, the last paragraph, Mr.
7th June 2005, after 2 years.
Oh, 2005, right. Ah.
Yes, similar, it also shows that after October 2005, except for that PCB license, no steps has been taken by them, except for writing letters. Now, this is followed by the termination, which is, as rightly pointed out to them, by them, that though passed on an earlier date, has been issued to them at a later date. And this, the trial judge has also taken note of it, This, in my humble submission, at best, is a termination order. It will at best take effect from the date when they come to know of it. Otherwise, the merits of the order cannot be vitiated because it was given to them after a period of a month. This case of afterthought, in my scanning, I have not found from the evidence which has been before the learned trial judgment. It has not come out in the evidence that it was in any kind of afterthought.
What was an afterthought?
That we had prepared it later and not on the date when it was supposed. The order's termination says 8 January 2008, which is the date of the hearing. But it is given to them in February 2008, 1st February 2008, after about 22 days. So they impute malice on the contents of the letter. Though, my submission is that this, at best, the effect is that
Yes.
the termination takes effect from 1st February, when the order is communicated to them. It does not dilute the contents of the termination. Now, page 186.
The termination letter is at page
180, covering letter 185.
Achha.
The order is at 186.
Yes.
This is in pursuance of the show cause notice dated 31st December 2007, by which you were given an opportunity of hearing. Your representative was heard at length on January 8, 2008, and all his submissions have been taken into consideration. You have submitted a statement in writing by way of a letter dated 8 January 2008, along with several enclosures, which too has been considered. The fact that you have not constructed and set up a supermarket comes so and so with some residences to the staff with the time period of 3 years from the date of grant of license on 22nd May 2003 appears to be an admitted fact. Your explanation that the land title is not clear is not acceptable, as because to this date you have not even once informed KMDA of any defect in land title. You have not even informed KMDA that the project is being held up because of the defect in land title. From the property tax receipt enclosed with your letter, it is evident that your name has been entered into the records of the municipality as a licensee of the above plot, proving that the KMC's point of view there has never been any dispute as to the status of the land. Even in the absence of this, it is evident from the documents submitted by you that you are the licensee and KMDA the licensor. The question of further clarification to KMC in this regard does not arise, as because KMC has already entered your name in their records in respect of the plot of land in question, and KMC has not rendered any matter in this respect to KMDA.
Mr. Bandyopadhyay, apart from that allegation of verbal communication to them that there is no title, there is no
Nothing. There is nothing. Not a single document from any authority writing to them that give us a lease deed, or because of KMD's
title.
faulty title, I cannot give you this license.
It is not there.
Nothing. Your application dated 10th March 2006 to the West Bengal Pollution Control Board on the face of it is grossly delayed and is almost 3 years after the license agreement. As per the relevant provisions in the license agreement, the project should have in fact been completed by this time. You have contended that you have taken some steps like applying for explosive license which are exorbitantly delayed and not supported by ground activities. There is no activity of execution of project till date on the ground, including the soil testing and preliminary preparatory works. Similarly, the building plans have not been prepared till date. Thus, there appears to be serious endeavor on your part, no serious endeavor on your part to set up the project for which the license was granted. The license deed was executed in order to enable you to proceed with the construction work immediately. Despite that, you have not proceeded with the implementation of the project, although you were empowered under the license deed and had sufficient scope to erect, construct, and complete the proposed project within the time frame given. Several other allottees of KMDA have completed their projects on the basis of license deed.
Sorry, half a minute.
আছে।
আছে পেপার বুকে আছে
হ্যাঁ
Yes, Mr. Madhav, please.
কত কথা বললেন
একবার sorry।
Well, I was reading at 187 first paragraph.
Yes.
Middle. Several other allottees of KMDA have completed their project on the basis of a license deed similar to the one granted to you. You have not even prepared the building plan till date and even could not justify your action of not doing so. KMDA allotted land to different parties in the prime area for the purpose of implementing public utility services to set up business centers, industrial institutions for economic development and for construction of commercial and cultural complex in the interest of the society and public good. Time is an essence in the implementation of these development projects. The particular allotment has lost all relevance and land is lying unutilized for long. Further, KMDA being a public authority does not only earn revenue from the sale of land but also ensure that the land allotted by the authority are used for overall development of the city. This amounts to holding land with the intention of and speculation which cannot be allowed by a public body like KMDA. It is apparent from the records and established that you have transgressed the covenant to be followed by you regarding completion of the construction of the project within a period of 3 years from the date of execution of the license deed in your favor, and whereby it shall be lawful for KMDA to determine the license and to re-enter upon the land as stipulated in the license deed. If any relaxation is made in this case, it will amount to giving undue consideration and failure to implement the job being virtually rewarded. Further, the land is lying vacant and neglected with just a small temporary structure that lies closed. You have not taken electricity and water connection for the land, nor taken any steps for initiation of infrastructure work. The position is such that the property is in danger of being encroached by third parties. License was granted to you with the object that you would set up a supermarket cum food processing unit at the site which will provide economic boost to the area. However, there has been a total failure on your part in achieving this objective. For the reasons aforesaid, you are in breach inter alia of covenants 5.3, 4 and Roman 13 of the license deed, and therefore the license is hereby cancelled. Though it seems to me that this Roman 13 will be 8, but anyway, I think this order, this termination decision stands singularly on 5.3 and it is good enough reason for it to stand. It is not that from the body of this order some other meaning or some other import is discernible also, which can create any confusion as to what was the reason for termination. But though an elaborate order and the orders we defend in the writ petitions, it is better than
Right,
very
surprising.
well draft, surprisingly, but still, luckily, even if it was a little badly drafted letter also, your lordship will rather look at it from the point of a commercial transaction and a commercial man rather than an equitable considerations. which should follow, my lord, in the case of a writ petition, had they challenged it in a
Not
writ
supposed
petition.
to be a judicial mind.
Yeah, in fact, this reminds me that in fact there was a challenge in the writ petition, and thereafter they were relegated to a suit.
Yes.
Therefore, the consideration of 226 will be kept out of it because it has already been considered by
Done.
this court that it will be treated as a commercial transaction, and it will go by the license deed, like two businessmen who has entered into the agreement. One document I have missed, my lord. I am grateful to my learned senior, my lord. One document I had.
এখানে তুই মাথা নম্বর চেয়েছো সেটা দিয়েছি
No, for the page. I had missed this, my lord, in my notes. Page 160 of the paper book. My lord, this is to the KMC that they had written, a letter written to the KMC. My lord, kindly takes the page 161, the second part of the letter.
Yes.
Then, second paragraph in 161. The permissible ground coverage is 40% and we have covered 43.95 in our proposal. We have maintained a slope in the ratio of 1.10 for the walking ramp all through. The ground coverage of the walking ramp with lifting bay works out to so and so square meter approximately. The lesser of the plot is KMDA, a body corporate under the West Bengal Town and Country Planning Act, and we are the lessee of the plot. This is a wrong information given to KMC. Therefore, NOC from the competent authority of the Urban Land Ceiling Authority may not kindly be insisted upon. We therefore appeal before your good self to kindly make it convenient to relax the subject matters as prayed for, considering the involvement of investment in the huge industry in the city of Kolkata. But the purpose of me coming back to this letter, which is that first of all they misrepresented before the authorities, and on the basis of that misrepresentation, they want a relaxation under the Urban Land Ceiling Act and also in the ground coverage area, which in my understanding complicates the situation rather than streamlining it and making it convenient for themselves to do it within a particular time. They rather make requests before the authority that since I am a lessee under a public authority, statutory authority, you kindly give me certain relaxations. But these were not really necessary if we see the intent with which they should have proceeded with the work. For the purpose of for defending the impugned order, perhaps any other document is not required. One or two documents may be required for Can 4, but for this purpose it is not required. Now, my lord, one of the thrust in the argument that whether this license was a lease or not. Now, my lord, first your lordship will kindly see. First of all, it is not there. Your lordship has seen the 5 issues numerous times. It was not even an issue before the Honorable Learned Trial Court. Secondly, kindly see the plaint. What is the plaint case? And only 2 parts of the cross-examination I will show of the PW1. Where the PW1 himself accepts that he has nothing to show that it was a lease. But if your lordship takes volume 1, page 15 onwards.
No, it is their case that it was a license, but they say that it was your obligation as per the brochure and the other whatever you gave out, that you had to execute automatically lease deed would follow upon compliance. And they also said, Ms. Agarwal probably argued that you misrepresented that you did not have title at that point of time.
There cannot be. In fact, if your lordship, even if your lordship need go into,
You had executed documents to others or something.
in the license deed,
Yes.
it starts by saying that since I am not in a position to give the lease now,
Yes.
I am giving you a license deed so that you can
You
start the
cited you not
construction.
having title for that.
Yes,
the lease
and
deed.
it is within their knowledge also.
They say that you had title at that point of time, but you did not.
If their knowledge, if your lordship takes volume 1, page 15, para 7. They are plain para 7.
Yes.
In course of discussion, the plaintiff informed by the defendant authority that the title of the property is yet to be cleared by the land acquisition department. As such, till such clearance is being given, the plot can be registered as licensed deed, and the said deed will automatically be converted into lease with power to grant sublease or so and so. This is their plain case.
No, you gave that impression, but you had title actually.
And if the documents exhibited
Then
by
my-
them,
Take it.
Then my case is better.
Why?
Then my case is better. But if I had the title at that point of time, and I gave a license deed, their entire defense that today's defense, not contemporaneous defense, today's defense that I could not start the construction because you did not have title. You had a faulty
No,
title.
you had a title, but you did not give them a lease.
Very good. But if that be the case,
But you gave out in the license deed itself that you did not have title. And that's why you are not
very
giving.
good. But that, assuming that was the misrepresented by us,
Hmm.
that has in no way hindered their position in constructing within 3 years.
Because you fall back in any event in their delays and that no authority wrote to them that title is an issue.
Yes, title is an issue.
Or their not being a lessee is an issue.
Right.
So even if there was a misrepresentation, suppose, let us take the worst against you, then also that did not come in the way of their getting a sanction plan or their getting anything.
Well, if we go through the timeline again, they required a mutation from KMC. They applied, they got it. They needed a building plan from the KMC, sanction building plan from the KMC. They applied. There was a meeting of the building committee which in principle approved it, but said that NOC and etc. from certain other authorities are required. When this order is issued on 28th February 2005, then they get activated and they start applying. In fact, one application they make, their activation is such that they make the application after 1 year. These are the causes of delay. The causes of delay is not my title. There is no problem with my title.
But they applied for sanction plan in well within a reasonable time.
Yes, they applied for sanction plan, that the date I pointed out
Yes.
from page para 29 of the plain, at least on 28th December 2004.
Yes.
1.5 years.
1.5 years.
layout plan was given on 17th December 2004.
Now, one other aspect of the matter, Mr. Bandyopadhyay, we are making it more nuanced in the sense that in the lease deed that 3 years, let us come to that clause 5.3 once. What was the page number, please? Can you?
But
44.
44.
45.
Yes, we've got it. 42.
42, my lord.
42. Now, if you please come to page 42 of part 2.
Fine.
Now, there it says at the own cost within 3 years from the date hereof, or within you have not given time, they have not applied.
They are not
Within 3 years. Then it continues in accordance with plans, sanctions should be and specifications as shall be approved by the appropriate authorities on payment of such fees as required
Yes.
in accordance with the building rules.
Right.
Now
Of the claims.
now they apply for a plan. Why shouldn't this clause be this 3-year period be deemed to strictly be an essence, because this is circumscribed by in accordance with plans.
Yes.
So this 3 years, suppose they apply, they try their level best, but the plan does not come up. The sanction plan is not issued by the appropriate authority. Shouldn't this 3 years time be deemed to be directly taking into consideration that the appropriate sanction, because this is read into it, it's intertwined. The 3 years starts, that construction starts and is completed subject to sanction plan.
In accordance with sanction.
In accordance with sanction,
Sanction.
it has to be in accordance with, obviously it has to be.
It was not required to be written, but it has to be
Not required to be written. But therefore, these 3 years, within 3 years, within a reasonable time, they apply for sanction plan. Suppose sanction plan is not given for no fault of theirs. Now, why should we say that these 3 years should be strictly the essence, even if they don't get a sanction plan despite applying within time?
Well, there were two remedies. One is to pursue it against the KMC. Or second is in the second line of this clause that
They could approach you.
for that time.
They could approach you.
We could apply our mind to say whether it was sufficient and reasonable ground or not. And if that application would have been made, also this argument could have followed that in this case, time was not the essence of the contract. But merely because this clause is there to argue that since the extension clause, time was not the essence of the contract, though none applied for it, now extension was granted for it. Malad, this last part, Malad, if your lordship actually sees it, is basically a surplusage. Because Malad, the building has to be constructed in terms of sanction plan. There is no other way. And no public authority will say that you make construction without the sanction plan.
Yes. And the other ground we are not even asking you because this Calcutta does not advert to any of the documents.
Malad, before your lordship, Malad, takes a recess, Malad. Malad, this, if I may, if your lordship is having volume 1,
Yes.
if your lordship takes page 171, on that lease license aspect, Malad,
Yes.
will be an appropriate closure on that. It is the cross-examination of PW1.
Yes.
Second paragraph, fourth line.
Right.
I cannot state whether KMDA had accepted me or not as lessee by writing letter to KMC to that effect or not.
This means nothing. The lease,
This is the only,
the license deed is before us.
the lease and license, this is the only bit of the
Evidence.
evidence.
And regarding the trial court having not considered, maybe obviously you'll have two arguments that nothing hinges on those documents.
Number
One, secondly, order for rule 20, order 41 rule 24 is also there. We can also look at it.
gives the reasons, my lord, if the ultimate conclusion is justiciable.
Justifiable.
But my lord, I have not concluded.
No, no.
5 minutes.
Huh?
5 minutes break.
You have just concluded on one of the topics, one of the ideas. Will be correct.
করিয়ে দেবে।
গরম লাগবে তো। বয়স হয়ে গেছে।
আমার গরম লাগবে।
বয়স
হ্যাঁ,
হয়ে গেছে।
বয়স হয়েছে।
Yes.
Kindly takes my lord 169, volume 1. This is also the cross-examination of PW1.
Yes.
Fourth paragraph, fourth answer. I did not inform the defendant KMDA that I had applied for obtaining of the sanction plan from KMC. The date we got from the plain, my lord, there cannot be any knowledge as far as my lord KMDA is concerned. So we'll have to discern the date from them, which automatically will also, my lord, infer that they did not discuss the sanction plan or the pendency of the sanction plan with us. Next, kindly skips over one answer. I did not inform defendant KMDA regarding my requirement for further construction. I did not file any case against the persons who disturbed my possession by claiming ownership. These are those intermeddlers who were coming and
Exactly.
disturbing their possession. So, my lord, as far as KMC is concerned, their hindrances were not really brought. My endeavor to show these three answers is that their problem areas, building plan, people coming and disturbing their possession, these were not really brought to my notice, which also goes in line with my argument that during the currency of the lease deed, they really did not approach me for any assistance. Well, 171 I have already shown. Next, my lord, 171, one part I have shown. Can you take the bottom of 171? On last two lines. On 8th January 2008, Manish Agarwal, one of the directors of the plaintiff, had personally appeared before the KMD office. Manish is my son who lived with me. The minutes were prepared regarding the Manish's visit at KMD office on 8th January 2008. On that meeting, nothing fruitful was happened. I cannot state whether those minutes papers have been filed by me or not, as because I cannot recollect that. Therefore, the hearing was attended by his son Manish, who is one of the directors. He is PW2. Now, my lord, in PW2, kindly take one paragraph of the chief at page 177 top. That is his paragraph 7 of the chief.
Yes.
I requested to the special secretary of the KMDA to grant an opportunity of hearing to the special secretary. KMDA did not allow me to make oral submissions. This militates against that finding in the order which says that elaborate hearing has been given. That is the first paragraph of the order of termination. Now, my lord, kindly takes his cross-examination apropos to this chief. 178 bottom.
Yes.
I have no document to prove on 8 January 2008 at about 10:30 am I had visited the office of the KMDA. Then in the next page, second, I have no evidence to prove the fact which I have stated in paragraph 7 of my chief. But then he volunteered to say that I have document to prove the fact of paragraph 7 of my chief, but that document, perhaps subject to correction, did not see the light of the day.
But what document could he have? That he
Maybe
was not
not-
unless your person
For hearing, there cannot be any document.
no hearing given, there cannot be any.
So it is therefore, my lord, the version versus version, my lord, that
Has
the
to be.
impugned order. But my lord, their contention, your lordship will find in the order, not the impugned order. I'm sorry.
They admit up to this that they were present
They were present
and their written
hearing was given.
representation was
But they say
written
that it was not fruitful. They say it is their case that it was not a fruitful hearing. But I am not on that. What I'm trying to say is that my lord, their points have been dealt with in the order of termination.
Yes.
And a show cause was given to them.
No, also the written objection was considered.
Was
He
considered.
admits that written objection was submitted.
Yes, yes. My lord, one paragraph of the plaint, one argument was made that construction has been made by them and thereafter renovated.
Hmm.
This argument was made by them. for that purpose, kindly take paragraph 39 of the plaint. That is at page
25.
25. The plaintiff states that at the time when the said plot of land was handed over to the plaintiff, there existed a small structure. And in order to immediately start its work, the plaintiff duly renovated the said structure and started a food processing unit therefrom and obtained a trade license for Kolkata Municipal Corporation. So one structure which was our structure, which was already there, they might have only renovated it. The structure was never constructed by them. Now, my lord, firstly, one decision will be common between us. That is AIR 59 Supreme Court 1262. Then my learned senior has relied on in the compilation. She has relied on paragraph 27. It appears from the index of the compilation. That starts at page 25 of the compilation.
Yes.
Mother will kindly take para 28.
Yes, para 28.
So this is on the lease and license.
Lease license, yes.
So there is a marked distinction between the lease and license. Section 105 of the Transfer of Property Act defines a lease of immovable property as a transfer of a right to enjoy such property made for a certain time in consideration of a price paid or promised. Under Section 108 of the Act, the lessee is entitled to be put in possession of the property. A lease is therefore a transfer of an interest in land. The interest transferred is called the leasehold interest. The lessor parts with his right to enjoy the property during the term of the lease, and it follows from it that the lessee gets that right to the exclusion of the lessor. Whereas Section 52 of the Indian Easement Act defines a license, thus, then the quotation I was skipping over, Malab. Under the aforesaid section, if a document gives only a right to use the property in a particular way or under certain terms while it remains in the possession and control of the owner thereof, it will be a license. So this is my case. The legal possession, therefore, continues to be with the owner of the property, but the licensee is permitted to make use of the premises for a particular purpose. But for the permission, his occupation would be unlawful. It does not create in his favor any estate or interest in the property. There is therefore a clear distinction between the two concepts. The dividing line is clear, though sometimes it becomes very thin or even blurred. At one time, it was thought that the test of exclusive possession was infallible, and if a person was given exclusive possession of a premises, it was conclusively established that he was a lessee. But there was a change in the recent trend of judicial opinion, is reflected in Errington versus Errington, wherein Lord Denning, reviewing the case law on the subject, summarizes the result of his discussion, and thus at so and so. The result of all these cases is that although a person who is let in exclusive possession is prima facie to be considered to be a tenant, nevertheless he will be held to be so if the circumstances negative any intention to create a tenancy. The Court of Appeal in Cobb versus Lane considered the legal position and laid down that the intention of the parties was the real test for ascertaining the character of the document. The solution that would seem to have been found is, as one would expect, that it must depend on the intention of the parties. Denning LJ said much to the same effect at so and so. The question in all these cases is one of intention. Did the circumstances and the conduct of the parties show that all that was intended was the occupier should have a personal privilege with no interest in the land? The following proposition may therefore be taken as well established. Number one, to ascertain whether a document creates a license or lease, the substance of the document must be preferred to the form. The real test is the intention of the parties, whether they intended to create a lease or a license. If the document creates an interest in the property, it is a lease. But if it only permits another to make use of the property, of which the legal possession continues with the owner, it is a license. If under the document a party gets exclusive possession of the property prima facie, he is considered to be a tenant, but circumstances may be established which negative the intention to create a lease. So up to this purpose, rest is on facts. So, my lord, my permission for him to enter into the property, which would otherwise be illegal, is to make a construction there
Construction for a particular purpose.
And if you fail to do it, I will re-enter. It is this interest, there is no intention between the parties, and it clearly mentions that there are some licenses without mention of a lease. But here the mention of lease is there, which may make the line thin or blurred. But my lord, here it is clearly stated that this is preceding a lease. And sometime down the line, and there also one clause I read, my lord, that upon fulfillment of conditions, they will, my lord, get the lease subsequently. My lord, on the conditions, my lord, before going on to the next judgment, my lord, I was reading the clause on which a query fell from your lordship, my lord. My lord, I read it in my way, my lord. If I may point out something in that clause, but your lordships were at the part in the bottom second part of the
Yes.
clause. 42. That was at 42. If your lordship wishes to take a look at it.
42, right? Yes.
That the query which fell from your lordship, that
Yes.
if it is in accordance with the plans, sections, specification as shall be approved by the appropriate authority on payment of such fees, comma, in accordance with the building rules of Kolkata Municipal Corporation, with the requirement of any land use development control regulations or requirement of so and so.
Whether that dilutes the 3 years.
Yes,
That you
kindly
give a
sees the
more or less
intent of
satisfactory
the
answer.
parties that
Yes.
the word subject to is not used.
Right.
In accordance with.
Yes. Yes.
Therefore, the top half is not subject to getting a plan. Your plan is sine qua non. You'll
The
have to
duty
get
is
a
on
plan.
them to do it in accordance with.
Yes.
But that does not
Do not,
circumscribe.
what we merely say is that please do not put us in a position that you have constructed a building without following the
You
rules.
have to erect, complete, construct and complete
accordance.
within 3 years in accordance.
When the parties had the option of using the word subject to.
Yes. 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 Get
Subject to a sanctioned plan. This is not a case of subject to a sanctioned plan. They would have had good case if it was a subject to a sanctioned plan.
No, they have
Auto,
to.
it would have meant automatic extension of that type. The next decision on the same line is ILR 1978, Volume 1, Delhi, 292. ILR 1978-1, Delhi 292. সৌমেনসেনের ইয়েতে আছে।
আমি তো সব জাজমেন্টের কপি দিয়েছি তোমাকে, পুরো ভলিউম দিয়েছি।
নাও ডাক দেওয়া আছে। জানো will kindly take 50. Is a full bench decision. Kindly take 15. But may I give the paragraph that I will place, Manoj? 15, 22.
Yes.
15, 22, 24 to 26.
Thank you.
15, 22, 24 to 26.
Associated with it.
15, Manoj.
15.
50. The question accordingly is whether the various clauses of the document in question, when read as a whole in any manner, carve out an interest in the demised property in favor of the petitioners. Although a person who is let into exclusive possession is prima facie to be considered a tenant, nevertheless, if the circumstances negative such a conclusion and show that no tenancy was created, the person in possession would not be held to be a tenant. It is trite saying that the intention of the parties is the real test for ascertaining the character of a document. It is beyond challenge that if a document gives only a right to use the property in a particular way, but its possession and control remains with the owner thereof, it will be a license. In such case, the legal possession remains with the owner of the property. The licensee being permitted to make use of the property for a particular purpose. It would therefore be seen that the permission that the licensee's possession would be unlawful. Exclusive possession does not militate against the concept of a license. If the circumstances negative any intention, then the associated hotels has been referred to. Then 22.
The quotation from associated hotel.
Right.
That is
Yes.
associated hotel is called quotation.
Quotation paraphrase.
Para.
Paraphrase. It's not quotation.
What is quotation?
My learned senior is impressing that it's a quotation from associate hotels, but it is paraphrasing from associated hotels. It is not really a quotation, but same language like we use. Similar language. 22. License is defined in section 52 of the Easement Act and reads as under. Then the quotation I am skipping over, Mulat. From the above definition, it is evident that a license only makes an action lawful, which without it would be unlawful, but does not transfer any interest in favor of the licensee in respect of the property. Then 24. In the instant cases, the terms and conditions of the license coupled with the surrounding circumstances show that a bare license being a matter of personal privilege to occupy the kiosk was granted in favor of the petitioners and was revocable even though it had been given for a valuable consideration. There is a catena of authorities in support of the proposition that in the case of a license there is something less than a right to enjoy the property in the license. It cannot be exercised by servants and agents and is terminable, while on other hand, in the case of a lease, there is a transfer of right to enjoy the property, or in other words, the lessee is entitled to enjoy the property. A bare licensee having no interest in the property cannot maintain an action for its possession. A mere licensee has only a right to use the property. Such a right does not amount to an easement for an interest in the property, but is only a personal privilege to the licensee. After the termination of the license, the licensor is entitled to deal with the property as he likes. His right he gets as an owner in possession to the property. He need not secure a decree of the court to obtain this right. He is entitled to resist in defense of his property the attempts of a trespasser to come upon his property by exerting the necessary and reasonable force to expel a trespasser. If, however, the licensor uses excessive force, he may himself be liable to be punished under a prosecution, but he will infringe no right of the licensee. No doubt, a person is in exclusive possession of the property is prima facie to be considered to be a tenant. Nevertheless, he would not be held to be so if the circumstances negative any intention to create a tenancy. In the instant case, the petitioner's possession of the premises kiosk on the facts and circumstances of the case cannot be held to be conclusive evidence of there being a lessee, as the grant was not coupled with an interest in the property. The principle, once a licensee was always a licensee, applies pro vigore in these cases. The petitioners are not entitled to retain possession against the corporation, which can take possession of the kiosk and would be driven to a court of law, as a mere physical possession of the petitioners confers no right on them. The petitioners, therefore, in law are not entitled to retain possession against the corporation, having only the personal privilege to carry on their business, which otherwise, without the permission granted by the corporation, would be an unlawful act. These are well settled principles supported by Swans. So, Malad, this squarely, Malad, covers our case, Malad. That our right to re-enter on the property upon the termination. I need not go to the court, Malad, to obtain that possession. And in fact, Malad, since valuable consideration, it reminds me that, in fact, in our case, we had offered to give them the consideration back. The offer was there to give the consideration back. 77 টাকা কোনটা
বলছি যে সত্যি বলছে ফ্রেশ কপি দিয়ে দেবে, তোমাকে একটা সেট তোমাকে দিয়ে দেবে, যদি ওর মার্ক করা কপিটা যদি পরে একটু দিয়ে দাও।
তুমি দিয়ে দেবো, কেন দেবো?
আমি 9 আর 12 টা করে
Well, this is AIR citation type of thing. But I'm giving the AIR, but the paragraphs are the same. This is AIR 1977 Supreme Court 1496, which is equivalent to 1977 Volume 3 SCC 457. But this is on the point that how I am to be treated, though I am a public body.
But the-
77 3 SCC 457.
but the-
9 and 12, Mullah. Dr. Singhvi's argument that state government had some special obligations attached to it would have appeared more plausible. It could be shown that the state or its officers or agents has practiced some discrimination against the petitioner appellant at the very threshold or at the time of entry into the field of contract so as to exclude them from the consideration when compared with others on any unreasonable or unsustainable ground struck by Article 14 of the Constitution. It is true that Article 14 of the Constitution imports a limitation or imposes as an obligation upon the state's executive power under Article 298 of the Constitution. All constitutional powers carry corresponding obligations with them. This is the rule of law which regulates the operation of organs of the government functioning under a constitution. And this is exactly what was meant to be laid down by this court in Eurasian equipments. Well, I'm skipping over the Eurasian equipment that is on 298 and 299. Well, kindly take paragraph 12.
Yes.
The Patna High Court had very rightly divided the types of cases in which breaches of alleged obligation by a state or its agents can be set up into three types. Where the petitioner makes a grievance of breach of promise on the part of the state in cases where, on assurance or promise made by the state, he has acted to his prejudice or predicament, but the agreement is short of a contract within the meaning of Article 299 of the Constitution. Where the contract entered into between the person aggrieved and the state is in exercise of a statutory power under certain acts or rules framed thereunder, and the petitioner alleges a breach on the part of the state. And number three, where the contract entered into between the state and the person aggrieved is non-statutory and purely contractual, and the rights and liabilities of the parties are governed by the terms of the contract, and the petitioner complains about breach of such contract by the state. This is my case.
But there have been subsequent judgments also
That
diluting.
there must be certain
Even in
rules of-
private, yes, private contracts,
Fair play.
yes, fair play, and you know that
In fact, my lord,
you're regularly facing the wrath of courts.
Yes. In fact, my lord, your lordship has also held that in compilation number, judgment number 6, which
Several that's settled. You know that.
yes, my lord, that is why, my lord, I took the endeavor to show the show cause, reply, their evidence.
Yes,
Where-
here,
yes.
your case is that you have acted in terms of the contract also.
And that being a state authority, that minimum fair play,
And
I
there
have
is no
to respect.
unfairness or discrimination or
Or-
arbitrariness involved here. That is your.
Since there was a blatant breach of one of the conditions,
Yes.
and since the land was lying there unutilized, we had to take steps to take back the land.
Yes. Rather, public purpose was, according to you, in your favor because
Yes.
that last line of the impugned judgment.
Yes. Penultimate paragraph.
Yes.
Then, my lord, other two judgments, my lord, I'll skim through it, my lord, because it's on the same point that the document is to be, my lord, interpreted as has been understood by the parties. দুশো পাঁচের নয় টাকা লাস্টে দেখাচ্ছি না পাঁচের নয় টাকা But there are very minuscule marking, my lord, kindly ignore. My lord, kindly takes 2005, sorry, I'm sorry, 2005, volume 9, Supreme Court cases 174. Kindly takes 19 and 21.
Yes.
In this connection, a reference may be made to a series of decisions of this court wherein it has been held that it is the duty of the court to interpret the document of a contract as was understood between the parties. In this connection, so and so kindly skips over the quotation, kindly takes 21. Therefore, the terms of the contract has to be construed strictly without altering the nature of the contract as it may affect the interest of the parties adversely. And what was the last judgment, 1999, volume 2, Supreme Court cases 37. So the condition for cessation of interest must be a valid condition. 1999, volume 2, SCC 37.
Yes.
So can I take paragraph 17?
Yes. 7.
All that section 32 of the Transfer of Property Act provides is that in order that a condition that an interest shall cease to exist may be valid, it is necessary that the event to which it relates be one which could legally constitute the condition for creation of an interest. If the condition is invalid, it cannot be set up as a condition precedent for crystallization of the interest created. The condition that the industrial unit shall be established within a specified period, failing which the interest shall cease, is a valid condition. So, clause 7 of the agreement between the parties is therefore a valid and binding upon the parties thereto. In our case, 5 Roman 3. In place of clause 7, 5 Roman 3. Therefore, my lord, just to summarize my argument.
Yes.
But I have argued that first of all, there is no evidence on record to show that there was any extension which was paid and extension which was granted, and showing that in this case, in fact, time was essence of the contract as has been found by the learned trial judge. Secondly, there is nothing to show that KMC has not given them a sanction plan because of any faulty title of KMDA or for any reason that I had a lease but I did not disclose it to them, or I did not have a lease, I did not disclose it to them, or for any either fault in title or any suppression which has been made by KMDA. Number 3, the allottee, that the licensee has accepted the license deed, knowing fully well that what are the terms that they will have to comply to see the light of the day as far as the lease is concerned. But those conditions were not fulfilled by the licensee even after lapse of a considerable period of time. Number 4, in reply to the show cause, for the first time they said that I wish to construct. But this is coming a bit too late in the day. It is coming almost after 1.5 years from the date, that is 21st May 2006, that the 3 years term has come to an end. And number 4 is from the evidence, that is page 169 of volume 1, it appears that the licensee never intimated us with regard to building plan, submission application for building plan, or any further construction, or any obstruction or hindrances that they were facing in making construction in the subject plot. So those are my.
Thank
ও একটা ব্যাপার ঠিক আছে मतलब refund এটা কোথায় well one judgment I'll just deal with मतलब well spun has been
Well spun.
well
Yes.
spun that is मतलब the second one in the
Yes.
compilation मतलब
Time is essence.
time is the essence मतलब my learned senior has had placed 20 and 34
20
I'm
and
not
34.
wrong.
Yes. Yes.
তাই তো
Stressed on 20 and 34.
20 and 34 though other paragraphs are
Other
mentioned
paragraphs mentioned, but 20 and
yes,
34.
20
Yes.
and 34 your lordships will find
42 deal with. Just like the
35 also. 20, 34, 35. Because that is marked in our.
yes
I didn't argue much on this, but
Pardon?
I didn't argue much on this point, but it was shown. Let him answer.
Yes.
Paragraph 42 is also.
yes
We are confident Mr. Bandyopadhyay wouldn't argue much on this point also.
no I'll just show one or two things मतलब it distinguishes itself it distinguishes itself kindly take compilation page 15 where
Yes.
paragraph 20 is there
Yes.
Mr. Sham Diwan, learned senior counsel, so and so has submitted
20 is actually not so.
that time was not the essence as the contract provided for extension of time as well as liquidated damages.
Yes.
In our case, it is not there except for the fact in 5.3 they can approach us.
No, Ms. Agarwal relied on the brochure,
But those are pre-contractual.
which you have already argued on.
That those
Yes.
are pre-contractual
Once the license deed is entered into by
Yes.
both parties, that becomes academic.
Yeah. and they have already culminated into a document.
Yes.
Then 34 I am skipping over So 34 I'll just read.
Yes.
That in order to consider the relevancy of the time conditioned obligations, we may observe some basic principles. Subject to the nature of the contract, general rule is that the promisor is bound to complete the obligation by the date for completion stated in the contract. That is subject to the exception that the promisee is not entitled to liquidated damages.
You get your point. The extensions were granted.
If by this act or omissions he has prevented the promisor from completing the work by the completion date. These general principles may be amended by the express term of the contract as stipulated in this case. In 35, kindly take the middle sentence. Merely having an explicit clause may not be sufficient to make time the essence of the contract.
Here, extensions were granted.
In this case, extensions were granted.
Very good. Yes, yes, Ms. Agarwal. Very short rejoinder. You've argued extensively over several days. He has taken much short
Or
time.
shall I argue it tomorrow morning?
Complete it, Ms. Agarwal. We'll just complete.
Tomorrow morning, give me 10 minutes.
Tomorrow
I'll
morning
not
you
have-
cannot because we have a single bench. So you'll have to come back on Monday. Then we have to
Monday.
keep this matter.
I'll keep it on
hanging.
Monday morning.
But then come prepared with your written notes
Yes,
of argument. Bullet points. Mr. Bandyopadhyay also.
I'll come with the bullet. I'll come with
You
the
have argued also on bullet points, so no difficulty. But
I'll come with the bullet
Ms. Agarwal, you just make it bullet points.
Yes, yes.
Not too many bullets, not too hard, not too sharp
very
bullets.
simple, not very short.
Soft bullets and small bullets. Yes.
Short notes.
Rubber pellet.
Rubber pill.
Rubber pellets.
Don't even mention. You will have to appear before several courts. Read courts. Yes. Anyway. Third learned counsel appearing for the respondent, footstep. On the prayer of learned counsel for the appellant, comma, the matter is adjourned till July 7, 2025 for the purpose of conclusion of rejoinder arguments by the appellant and filing of written notes of arguments by both sides.
But since your lordship is hearing the matter, I did not argue can 4 as such.
Can for what is that?
But can
That
4
will
they have
show
alleged
that
violation
the,
of the order.
Uh,
interim order.
Restoration
Position
of
must be restoration of
of
position and the position being taken over.
But we have dealt with everything in the opposition.
You
I'll-
should, if you
I
want
would have placed the opposition itself.
No, it depends because if they win the appeal, then in any event we'll have to probably ask you to give.
restore the possession. So can 4 is not really restoration is one thing. Another thing is the violation of the order that they said. And our argument was
Ms.
that they
Agarwal
are-
has not I mean, in that sense, not pressed apart from the restoration of possession part. এই সরি এটা
বইটা 5 ফিট বলে দিও
এটা যেখানে সাইটেশনস গুলো আছে তার
situation আমি বলার
ইয়েস নেক্সট
For the respondent, that's today below this. ঠিক আছে শুরু করো নাকি আমি বলবো শুরু করো led by Mr. Wasim Ahmed. Please on it.
Just remind us what is the matter.
The matter
You are too tall for the microphone. Take the microphone closer and upper. Yes, much higher. Has to go much. Yes.
also this
What,
matter
just remind us of the facts of the background.
the background is was that there was a the petition.
What was your suit for? You are the plaintiffs, you see.
I'm the plaintiff.
File the suit for.
There was a dispute, Lordship. One minute, Lordship.
Oh, you sought a declaration that your tenancy. You are tenants
Yes, Lordship.
under walk of estate. All
In
right.
a walk of estate. And previously, there was an order passed by the Commissioner of Works
Yes.
on page
91, 92.
91, 92. 92, Lordship.
Starts at 91, 92 is the order.
My prayer, Lordship. In that order, Lordship, in presence of my order,
Civil matters, so go to civil court.
civil court.
Very well.
That was the thing.
But you filed your suit in 2008.
2008.
So it's time barred. You have to overcome that first. What is your argument on that?
Lordship, that argument, my seniors,
That argument Mr. Ahmed will do.
Mr. Ahmed, he knows that.
Mr. Ahmed, what is your argument? We have just started.
Well,
What is your argument on limitation? You had argued, just remind us. I mean,
My lord,
we
the-
remember we have
the
taken
defendant
notes.
challenged, my lord, the tenancy in which was transferred in my name in the year 1990 with the Waqf board, my lord.
Yes.
Waqf board, my lord, passed an order, my lord.
Go to civil court.
Go to the civil court
Page
and
92.
agitate your
Yes.
grievance over there. That was in page 92 of the bill,
Yes.
which was passed in the year 1990, 16/1/1990.
Right.
So after this, my lord, the defendant never approached the civil court. They slept over their right, whatever the alleged right was there, and they never approached the civil court, my lord. Rent bill was changed in my name in the year 1966, first time.
All right. Rent receipts granted by whom? Their predecessors.
My lord,
Their predecessors. Rent receipts.
Waqf board, my lord. Waqf board is
Oh,
the
Waqf board. What is their claim? They are saying
they are saying, my lord, the case is that since the tenancy was in the name of the father, there was a mutual agreement between the brothers that my father's name would be mutated in the rent bill for convenience. For convenience, the rent bill, but that was never the case.
No, what do they claim? They claim to be the
They claim to be the co-tenant. They're having the right over the tenancy through the father.
co-tenant with you.
Co-tenant with my father. But my father and this defendant, Siddiq, are brothers.
All right.
Originally, my grandfather along with one tenant was the joint tenant. After the death of my grandfather, the name of my father was muted in the rent bill along with the other co-tenant. Now their case is that this name mutated in the rent bill was for the convenience of the family. So one person from the family, his name was given to the work board so that his name could be
But the
muted
rent
in
bill stands in the name of your father.
my father. And this was challenged in the year 1990 by the defendant.
Right. They were relegated to the civil court, did not
They did not
prefer any challenge. Till date, they have not preferred any challenge.
Nothing, not even the counter claim.
Not even a counter.
Not even a counter claim. But the trial court relied upon the documents which were filed by the defendants. That was the Exhibit D series, my lord, which was Lord, I will come to the, my lord, operative portion of the judgment, my lord, where they have dealt with where the trial court has dealt with the Exhibit D series, my lord. My lord, is the
What is this series?
my lord, that was a, my lord, an affidavit, my lord, which they claim, my lord, that is, your Exhibit D is, my lord. It was a letter, my lord, 125. This was a letter, my lord, which was alleged to have been given by my father to the official Mutawalli.
All right.
With an affidavit. But these documents were never admitted by my client, but by the plaintiff. Neither the signature appearing on the documents were admitted by the plaintiff. Lord, your lordship will find it from the cross-examination of my of the plaintiff, my lord, which is in page, my lord. Cross-examination is on, my lord, page 35, my lord. I'm subject to correction, my lord. That is page 35, my lord. Page 35, my lord. Further cross-examination of PW1 resumes this day, my lord. Has your lordship got it?
35.
Page 35, my lord.
Yes.
Second paragraph, my lord.
Yes.
One affidavit is shown to the witness. Witness stated that in the top of the affidavit, it is stated that one Noor Muhammad affirmed and declared this affidavit. Witness volunteers the signature appeared on the affidavit is not the signature of Noor Muhammad, my father. Not a fact that my father put his signature on the affidavit shown on 18/10/1966. Not a fact that it is stated in the affidavit that my uncle Muhammad Siddiq has also shared in the super. So this was specifically denied by the plaintiff in his cross-examination with regard to the genuinity of this affidavit. Moreover, my lord, the original copies were filed before the court with regard to the affidavit. I put a question to myself, my lord, if there was an affidavit.
No, these were not marked as exhibit?
Well, these were marked as Exhibit D with objection, my lord. With objection, my lord. If your lordship
The
says
evidence is X and Y for identification.
No, subsequently marked as.
Subsequently marked. All right.
These were marked as with objection, my lord.
Right. Those carried the signature of your father.
My father.
Alleged signature.
Alleged signature. Neither anybody from the Waqf board or the official Matali were produced before the court to prove the affidavit and the letter, so alleged letters given to the official Mutawalli of the Waqf.
How were they marked as exhibits? Who proved it? Mr. Mukherjee,
It was, my lord?
No, we are asking both of you. I mean, who proved the documents?
Nobody.
How were they marked as exhibits?
But it was marked as exhibit, my lord, with objection, my lord.
Even then, somebody has to prove it.
Somebody has to prove it. My lord, no such proof was, my lord.
It appears from the evidence itself that those were marked as X and Y.
My lord. My lord, kindly see the
Subsequently, was there a
page 53, my lord.
must have been a recall of the witness or
No,
something?
my lord, see page 53, my lord. I find this from the
53,
cross, further cross-examination of Chief of DW1, Sadiq Mirza, my lord. Siddiq
Huh.
Mirza, page 53, my lord. First, second, third paragraph, my lord.
Yes, yes.
I have filed the copy of the affidavit shown by Noor Muhammad. I have filed the letter addressed to the official Mutawalli. The letter along with the affidavit is marked as exhibit series after objection.
All right.
I have filed, but nothing in the chief was given that how did he obtain those documents? Nothing.
I once looks at the lockout record.
Sir, yes. Page 53 is very evident also. I mean, those were originals.
Those were originals. I believe that is what
No, I have filed a copy of the affidavit.
copy
shown
of
in-
the affidavits, my lord.
Mr.
Whether
Mukherjee also
these
ascertained whether those were originals.
were originals or the Xerox. I assume, my lord. I assume, my lord, it has to be a Xerox copy because if it had been an original one, my lord, then it should be with the custody of the official Mutawalli. So, my lord, if I see the further cross-examination of DW1, my lord, page 54, where the cross-examination of the witness was, my lord, taken. Page 54, my lord.
Yes.
My lord, I'll skip these second paragraph. I'll go to my lord. It's in the last
Yes.
letter is I, my lord. If I continue, my lord, I have filed an affidavit where Noor Muhammad signed on it. I obtained this deed from the court. Noor Muhammad came to swear affidavit. I mean, this was the explanation, my lord, of the defendant with regard to the exhibit D series, my lord. First, he says that this document was given to the official Mutawalli. Now, then in the cross-examination says that he has obtained this deed from the court.
This is a deed of partnership.
But with regard to the, my lord, affidavit, my lord,
Acha, very well. Affidavit. Yes, he refers to the affidavit. Affidavit. I have filed an affidavit here.
my lord, I put a question to myself, if it was given to the official Mutawalli, then how did you obtain this from the court? No explanation, nothing.
Court.
Suggestion was given, my lord. It is not a fact that Noor Muhammad did not swear this affidavit in the court of Presidency Magistrate Calcutta and that I obtained this said affidavit fraudulently.
Apparently, he means Presidency Court of Presidency Magistrate Calcutta. But if I swear an affidavit before the magistrate will not keep the.
Will not keep there. But since you say this was given to the official Mutawalli,
Yes.
but nothing in the record, my lord.
Yes.
And moreover, my lord, when you have challenged these rent bills of the tenancy being transferred in my name before the Waqf board, my lord. Since 1990, you did not take any steps. Even if there was a right, you slept over your right. And one fine morning, you come up with a written statement claiming your tenancy right over these suit premises.
So you rely on the rent bills which are in your predecessor's name?
In my predecessor's
In your own name or your predecessor?
In my predecessor's name.
Predecessor.
Now the court, my lord, relied upon this affidavit, my lord.
They had to revert that.
My lord.
So for that they produced these affidavits, which you say they did not prove.
It was never the signature. I have challenged the signature and the affidavit, my lord.
What about this rent receipts at page 96 to 105, Noor and Raitan?
Raitan Bibi. But Raitan Bibi was the other tenant's wife, my lord.
So
She
even
never
then,
came up with any application. I mean, she relinquished her right, my lord. After relinquishing her right, my name was exclusively
there is nothing
muted
to
in the
show
name.
that relinquishment. They did not take any point of non-joinder
No.
because of Raitan.
No, nothing. That was never the case. The court, the trial court on its own took up this issue that how come Raitan Bibi's name is not has been deleted from the rent bill.
No, but you did not prove anything to show that Raitan had
Because that was never the case, because since my father's name was there in the rent bill, I claimed my right through the rent bills, which was exclusively in the name of my father.
but
So,
right.
going back to the, my lord,
No, but Mr. Ahmed, the presumption of law is that if a tenancy is there, it is deemed to continue. The person says it has terminated, you have to prove it.
my lord,
Now, admittedly, 96 to 105 shows Noor was, your father was a joint tenant along with, or a co-tenant along with Raitan. Now, in the absence of anything to show that Raitan's the co-tenancy was terminated or she surrendered,
but
or it was
nobody is coming forward from the side of Raitan Bibi to challenge my rent bill. It is only the defendant who is coming forward and challenging the tenancy right, my lord, of my father.
right. And because Raitan is not challenging in any event, I mean, you can get a declaration maybe against him because he's challenging. All right. So page 106 to 110 in your father's name only.
My lord.
No.
No, it's
Here also
100,
plus
109, my lord.
109. yes.
109.
Ah,
108.
108,
100, rather 108, my lord.
108.
108.
yes. 8 and 9.
8, 9, my lord. 10. 8, 9,
to
and
10. 8 to 10, right.
And
Yes.
and it was within the knowledge of the defendant, my lord. It was within the knowledge of the defendant that the rent bill was changed in the year 1966 in the name of my father.
Because they challenged it in 1990.
1990. Even assuming, my lord, he has a right, but never came up with any counterclaim.
He does not claim through Raitan.
No,
He was the Ajaberul, yes. He
he's my
claimed
brother,
grandfather.
my uncle.
Your uncle, yes, right. Very good. What was the name of your grandfather? I mean,
My grandfather was,
Noor was your father.
my lord, Copeland Mirza.
Copeland was your grandfather.
Copeland.
So they say that Copeland was a joint tenant with maybe
With the husband of Raitan Bibi, Maqbul Mirza.
Acha. Through him Noor Muhammad, and he got the tenancy according to him.
My lord.
Very-
So Noor Muhammad and defendant are from Copeland Mirza, my lord.
Yes. Copeland was the father.
Oh, father and Noor and
defendant, yes.
brothers,
sons.
Sons, my lord.
So you can place the judgment. I mean, the relevant portion. This court has jurisdiction. Jurisdiction, let us forget. Issue 4 to 6 starts at page 68.
'27 is the issue, my lord, which was framed by the court. My lord. Page 21, my lord.
Yes.
Page 21, my lord. These were the issues, my lord, framed by the court. One was, is the suit maintainable? Second, my lord, have the plaintiffs any cause of action to file this suit? Whether plaintiffs are lawful tenants of the suit premises, which is being the property of Waqf state. Whether the plaintiff can apply for permanent injunction seeking for protection of the legal rights, if so decided in their favor. Whether the defendant has been in possession of the disputed property. Whether the suit property is collusive in nature. Well, these were the issues framed by the trial court, my lord.
Your exhibit. Let us come to page 68, Mr. Ahmed.
68,
Yes, where the main issues start, the adjudication.
my lord. Issue.
Before that, your cases.
Well-
4 to 6 have been dealt with.
my lord.
Now
I'll come directly to my lord, page, my lord, page 671, my lord.
very well. Yes,
This is exhibit series 5
right.
series that Noor Muhammad and Rayatan Bibi paid to the Waqf
Yes,
state
yes,
for
yes.
some months in the year 1971. So it is clear that previously the tenancy stood in the name of Koplain Mirza, Maqbul Mirza, and Rayatan Bibi. But this was never this was never
This is a
disputed.
sticking point, but
Ah.
this is a sticking point for us also.
But there is nothing in the plaint how the name of Rayatan Bibi and Maqbul Mirza were excluded from the tenancy as tenants.
It should
Because-
be deemed to continue unless shown to be terminated.
My lord,
That's the Evidence Act.
my lord, but
Certainly, even if rent receipt started being issued in the name of one, why
Yeah.
shouldn't it be construed that it was he was being issued the rent receipt on behalf of all the
but
co-tenants?
though this
Co-tenancy
rent bill was challenged by the defendant, my lord,
Yes,
that was challenged. So that issue was over in the year 1990.
not over,
But
but they sat tight from then. Suppose they don't challenge that issuance that the
if somebody
recording of
sleeps over their
right.
tenancy, my lord, their right, my lord.
Hmm.
But the court cannot, my lord. One fine day they will come up with a
So they had a cause of action which was canvassed
was-
before the commission in 90, relegated to civil court, never
yes.
made a declaration.
That is the crux of my, my lord, argument, my lord. Facts, my lord, I cannot change the facts. Whatever fact is there, my lord.
What about this running business exhibit A series, page 71?
But these are the rent bills. He said that he was there, he was carrying on the business, my lord, since 30 years. That was the statement made by the defendant in his written statement.
Yes.
But he produced, my lord, trade license for the year 2006, 2007, 2008, and 9. My lord.
Yes.
But trade license, my lord, with regard to the business, even assuming that he was carrying on a business, which I, my lord, which I have categorically, my lord, denied that he was in possession of the suit premises.
Hmm.
He was never in possession of the suit premises.
Hmm.
But by obtaining these trade license, my lord, I should not be saying this, my lord, how trade licenses are obtained, my lord, from the corporations will
Telephone bill, state
my lord,
license.
these, my lord, these things, my lord, can be obtained. But if I make an application before, my lord, the for any trade license for an electric meter, my lord, I will be provided with an electric meter or a trade license, my lord, without verifying whether I have a right over the tenancy or not, or whether I have any right over the property or not. My lord, even assuming, my lord, he has obtained a telephone bill or a trade license, my lord, but that will not, my lord, create any right over the tenancy of over the
But
premises.
it's an admitted position that Coplin was the father of Noor Muhammad, and
That is admitted.
That is an admitted position.
an
It
admitted
is up to
position.
that. It is admitted that Coplin was initially a joint tenant.
Was initial. In the year 66, when the rent bill of the tenancy was changed, my lord.
That itself does not extinguish the previous co-tenancy of this person.
I'm only
You are
on
the plaintiff here, even if they don't challenge.
I'm only on the limitation point, my lord. He had a right, my lord, which he did not exercise. That is my argument. Even if he had a right.
All right. We'll continue after the
My
decision.
lord.
My lord, before.
Yes. Yeah.
list. My lord, we'd taken leave yesterday, my lord, to move. This is an urgent appeal, my lord. I am seeking ad interim orders. It's a refusal of an ad interim order, my lord. I am told there's a 330 resolution also, my lord. Therefore, it's
Resolution?
unlikely that it will be taken up, my lord. The defendants are trying to alienate the property, my lord. It's item 9 of my lord's list. My lord had granted me leave yesterday.
Who is appearing for you?
My lord, this is ex parte. It's from an ex parte order of refusal. I'm seeking an ex
No
parte ad
caveat.
interim.
No-
No caveat. No caveat.
You
No
keep
caveat.
somebody, whenever this matter is over, we'll take up your
My-
matter, then the other matter.
My-
But may I have your lordship's leave?
If it is not over before 3:30, before
So
3:30,
we'll
just
take 5 minutes, my lord. It's just an ex parte ad interim.
Yes,
5
yes.
minutes whenever.
you keep somebody.
Yes.
I have your lordship's leave to mention a matter, my lord. This relates to the determination of Justice Banerjee. My lord, it's leave to file an appeal without the certified copy. My lord, I wouldn't have troubled your lordship. The urgency is another batch of appeals are listed on Monday.
Very good. Yes. Leave is granted.
I'm grateful.
May I have your lordship's
So,
kind
original
leave?
title.
May I have your lordship's kind leave to mention this matter for extension of interim order of determination of Justice Banerjee. If your lordship, I see the notification says today and tomorrow. I know my lord sits here.
Tomorrow we don't have a
My
division
lord
bench.
sits singly, but the notification says today and tomorrow.
Maybe, but
Hence, I'm
you should
taking
have
that.
mentioned before.
Lordship, it came out at 11:40. The
Would have
determination.
come up then in the middle
Lordship,
also.
I know, but then just took the.
Now we don't have any option to sit tomorrow. We have to disrupt the entire system then. Our lists are ready already.
I thought my lord is sitting tomorrow. That's why it's come out in the
No.
notification.
We are not sitting tomorrow because tomorrow in any
My
event we
lord
take up.
sits singly then.
And also that is broken into original side first half, second half, second.
Absolutely. my lord.
So it's impossible to disrupt that.
Yes. I'll-
Today, if they give the slip, if the file comes, when does it expire?
Lordship, it has expired on Monday. There's a reason, Lordship, Mr. Justice.
If it has expired on Monday, then mention on
I'll
Monday
wait
before
till
justice.
tomorrow and see where the determination
You
goes.
mention before justice.
I'll-
Yeah,
I'm grateful, man.
Key. Yes, Mr. Ahmed.
Before the break, your lordship was of the query that with regard to the telephone bills that he has obtained.
Yes.
But if you lordship goes to page 23, my lord, that is the exhibit C of that is the copy of the telephone bill,
Just come to that.
123. So if your lordship sees, there is installation date mentioned in the bill. When was it installed?
123,
123, my lord.
right.
The date of installation is, my lord, 1/3/2004. And he claims to be carrying on this business for the last 30 years. So, these, my lord, I made a suggestion to the DW1 in his cross-examination that you have obtained this fraudulently.
What was that affidavit signed by Nur Mohammed, which was marked as exhibit by them?
My lord, exhibit D, my lord.
D, yes.
Yes, my lord, that was an affidavit, my lord, stating that, my lord, the name of my
Page 130.
predecessor, page
130 must be. Acha, very well. So
it was
that
my
for
lord, page-
convenience, it has been
page
done.
125.
Yes.
Page 125. That was the exhibit D, my lord.
130 is also there.
130 is also there, my lord. But these affidavits were never, my lord. I have never, my lord, accepted these affidavits to be signed by my father.
But Nur Mohammed, was he alive when these documents were exhibited? Otherwise, how could they prove the signature?
My lord,
Nur Mohammed, if he was not alive,
Lord,
the
when?
relevant point when it was exhibited,
my lord, he was not alive, my lord. Nur Muhammad was because predecessor of the Nur Muhammad has filed the case. So
Successor.
Successor, my lord. Sorry, successor, my lord. So these signatures were never admitted by.
but
relatives, my lord.
page 125 isn't it an official? Oh no, Nur Mohammed's letter.
But it's a Nur Muhammad's letter, my lord. to the official Mutawalli, my lord.
Very
But
well.
never, nobody from the Waqf board or the official Mutawalli was called upon to prove these documents.
Very well.
So, my lord, with regard to the telephone bills and the trade license, my lord, I had made, my lord, suggestions to the DW1, my lord, that you have obtained these documents fraudulently, my lord. And the date of installation is very clear, my lord. It was installed in the year 2004, and you claim your tenancy, you claim your business, you are carrying on this business for the last 30 years.
All right. Very well.
But with regard to the possession, my lord, that he claimed that he is in possession, my lord. He was never in possession, my lord. That was my argument before the court, my lord, before the trial court, my lord. In his written statement, he says that he was in possession, but he was thrown out forcibly by the plaintiff. In his written statement, my lord. If your lordship comes to page 16, my lord, that is the written statement, my lord, part of the written statement, my lord, filed by the defendant. Page 16, paragraph 16 of the written statement, my lord.
Yes.
If I go to 1, 2, 3, 4, 5, 6, 7, 8, 9, my lord, I'll read out moreover, my lord. As your lordship got in the middle portion, your lordship will find moreover.
Yes.
The plaintiffs.
Yes.
Moreover, the plaintiffs have forcefully taken the possession of the suit premises after getting the order of injunction, and the defendant presently faced a great hardship to live with his family. So you claim this possession was taken forcibly, but still you choose not to file any counterclaim. Then, my lord, just in the upper line, my lord, that 30 years which I was just arguing just now, my lord, that in this connection, the defendant said is carrying on business in the suit premises for last 30 years, and documents will speak for itself, and the question of attempt forceful of the suit premises does not arise at any point of time.
Yes.
So you get your telephone installed in the year 2004, and you claim that I'm carrying on business for the last 30 years.
No other document of business apart from telephone?
Nothing.
Trade license or something?
Trade license, my lord. Trade
Trade
license has those trade licenses all after 2004, my lord. 2004, nothing before 2004. No, nothing before 2004. Not a single trade license before 2004.
Oh, previous trade license in the name of Janab Copeland.
Copeland Mill, yeah.
What document of possession have you shown?
My lord.
Have you produced any document that you are in
But
possession?
it is their case, my lord, that I'm in possession. They have admitted. Rent bill in the name of my father, in the name of my predecessor.
Copeland is their predecessor also. That is the difficulty.
But previously, in the year 66,
After his demise, Nur Muhammad
after his demise in the year 66, my father came into scene.
Your father could not have come alone. Shaklin also came. Shaklin or
That yes, that Mirza, Maqbool Mirza and Raitan Bibi, the joint tenants, who were the previous joint tenants.
no, Siddiq Mirza.
Siddiq Mirza is my brother, but his name was never there in the rent bill. Although he exercised his right before the Waqf board by claiming that he has a alleged right over the suit premises in the year 1990, but after that, no, nothing.
Achha, the rent receipts which have been produced, is there any single rent receipt where their name is also mentioned? No.
No, not single receipt.
All Nur Muhammad and Raitan.
Raitan Bibi. And after the Raitan Bibi, my lord, all alone the name of my father was there.
Only no. Very well.
My lord, the trial court, my lord, in the judgment, my lord, has relied solely on the documents, that is Exhibit D, and the trade license filed by the trade license and the telephone bill that has been filed by the defendants, he relied solely on those documents, although I have never admitted those documents. My lord, if your lordship sees the judgment, my lord, comes to the judgment.
Yes.
Page 60. The judgment starts from page 61, my lord. And the findings, my lord, decision with reasons.
You can come directly to issue numbers 4 to 6, page 68.
Come directly to page 71, my lord.
Yes, yes, better.
Page 71. From the documents, my lord, paragraph, second paragraph of the
Yes.
page, my lord. 71.
Yes.
From the documents which has been marked as exhibits on behalf of the defendant, it appears that a license was issued by the KMC in the name of Noor Mohammed and Siddiq Mirza on 11/8/2004, which was valid up to 31/3/2005. Exhibit A series further shows that the name of principal defendant has been shown as the licensee for running business in the suit premises for the year 2006-7, 2007, 2008, and 2008-2009. Exhibit series also shows that the name of Coplain Mirza was recorded for running a business in the suit premises. It is revealed from Exhibit C series that the name of the principal defendant has entered in the telephone bills in respect of the suit premises. It may be stated that in the written statement, the defendant has taken a plea that he has his STD ISD business along with a pawn shop in the portion of the suit premises. It may be further stated that from the Exhibit D series, it is revealed that there were 4 tenancies in respect of shop room number 2, 3, 4, and kitchen shed, and also room number 13 at St. George Gate Road, Kolkata 22. Noor Muhammad submitted the application to the official Mutawalli, stating entirely that after the death of his father, Coplain Mirza, he along with his younger brother, namely Muhammad Siddiq, sister Ajmeeran Khatun, and mother Zohra Bibi became the tenants by way of inheritance, but for the purpose of convenience to run the business, his name may be used for running the business in the said tenancy. Exhibit F also shows that Coplain Mirza and Maqbul Mirza were the original tenants of the suit premises who executed the registered deed in the year 1965. It also appears from Exhibit E that said Coplain Mirza appointed his 2 sons, namely Noor Muhammad Siddiq Mirza, as his constituted attorney for running the said business in the suit premises. It is curious enough that the plaintiffs did not state the names of Coplain Mirza, Arayton Khatun in the plaint, who it should be whose who names appear in the rent receipts as well in the documents as have been stated in the foregoing paragraph. Apart from that, the documents which have been exhibited as exhibits on behalf of the defendant clearly shows that he has also running his business in a portion of this suit premises. It also revealed from the documents filed by the parties that for the sake of convenience of running the business, some affidavits and letters were signed by the parties as well as the legal heirs of Coplain Mirza for issuing receipt in the name of Noor Muhammad. But it is also clear that this principal defendant was all along running his business in the suit premises, which has been corroborated by the trade license, telephone bills, etc. So the trial judge solely relied upon the documents of the defendant.
The rent receipts were produced by you.
Yes. That is not disputed, my lord. Even that those rent receipts were never the counsel for the defendant never raised any objection. It was formal proof dispensed with, my lord. It was dispensed with formal proof. So, my lord, the documents which were specifically denied by me, the documents which were obtained in the year 2004, the trial court solely relied upon the documents of the defendant.
The exhibit E has also been relied on where Coplain appointed his 2 sons, Noor
that
and
was that even if that isn't taken into consideration, my lord, they were appointed as a constituted attorney. Even if that is taken into consideration, they were appointed as a constituted attorney to run the business.
yes.
Business.
From the suit premises.
The suit premises. But business and suit tenancy of the suit premises are, my lord, two different things, my lord.
Very well.
Not only that, my lord, the trial court came to a finding that the plaintiffs are illegally occupying the suit premises. Although no such issue was framed with regard to the legal or illegal occupation of the suit premises. If your lordship sees that, my lord, page 73, last paragraph, my lord. On the other hand, from the evidence of DW1, it has come out that he runs his STD as the business along with a pawn shop in a portion of the suit premises. He has also produced relevant licenses, telephone bills, etc., which has been marked as exhibit. It is also revealed therefrom that this defendant has his business in a portion of the suit premises. DW2 has also stated such facts. According to this witness, after expiry of Nur Mohammed, his sons are illegally occupying the suit premises in which the defendant has also his share to the extent of 8 annas. Therefore, it is clearly established that these plaintiffs are not the exclusive tenants of suit premises, and since the defendants being one of the legal heirs of complaint has been carrying on his business in a portion of the suit premises, the plaintiffs are not entitled to get any degree of permanent injunction to said defendant. In the foregoing discussion, based on evidence, my lord, my suit was, my lord, dismissed, my lord.
When did Copeland die? Is that, has it come out from
Copeland,
anything?
1965.
Copeland died in 1965.
Yes, Copeland Mirza died in the year 1965.
Huh? Very well.
So, my lord, I'll cut short my argument, my lord. Since the defendants, after challenging the tenancy in the year 1990, kept quiet, they never asserted their right before the civil court. My lord, the law of limitation will apply here, my lord. They will be barred from claiming that any tenancy right over the suit premises, since you did not exercise your right for such a long time.
But limitation, the law of limitation, Mr. Ahmed, diverts one from filing a suit, but does not take away the defense. Substantive right is not taken away by limitation. That is also settled. I can take it as a defense in a different suit.
Well, it can be taken, my lord, but the
I cannot file a
circumstances, my lord,
suit. Limitation is for filing a suit for declaration. They cannot.
when you exercise your right, claiming a tenancy right over the suit premises, and
Yeah.
then you kept quiet for such a long period, my lord, that goes to show that you have expressly or impliedly you have relinquished your right.
All right.
Right.
Thank you. Yes.
Lord, my learned friend
Yes.
has argued, my lord, whatever, my lord, the last observation of my lord, it's the plaintiff, my lord, who has to succeed in his own case. It's not about my defense and anything else. It is the plaintiff who has made out a case before the court. What case he has made out? If Lord, my lord has already seen the plaint.
After Copeland,
My lord, it's no,
no became.
no. That is also not the case made out. Kindly takes up the plaint.
Yes.
one Noor Muhammad, paragraph 1, because I could have understood that essential question of facts with regard to the implied surrender is being at least pleaded in the plaint.
They started from Nur Muhammad.
Yes, that's where I am on. Kindly takes up paragraph 1. One Noor Muhammad, husband of the plaintiff number 1, and the father of the plaintiff number 2 to 4, and the pro forma defendant number 2 to 4, was a tenant in respect of the tile shed room, hotel room, Pakka Southeastern with pawn shop attached to the hotel under the Waqf estate of Lashkar Lane. Thereafter, my lord, I am skipping. So, my lord, the initial tenancy pleaded in the plaint in the name of Noor Muhammad. Now, my lord, kindly takes up paragraph 3 is the Noor Muhammad died sometime in the year 2007. And, my lord, these are the, kindly takes up paragraph 4 also. The said Noor Muhammad, because I will, my lord, compare this with my, my lord, document which I have produced. So, up to 2007, the Noor Muhammad, that is the father of the plaintiffs and the brother of the present defendant. He died in the year 2007. And what is the case in paragraph 4? That he said Noor Muhammad carried on business of Eaton House in the one portion of the suit premises and conducted another business of STD, stroke ISD and PCO and Panbiri in other portion of the suit premises.
So at least
so
up
it is
to 2007.
yes, at least up to 2007. So the running of business is also STD and ISD both. And my lord, paragraph 7 is the cause of action. That sometime in the year 2007, so his father's death is 11th of May 2007, and my overact, which prompted the plaintiff to file the suit, is 31st of December 2007. So, till the death of my brother and their father, there was no difficulty. So, immediately after the death of his father, who is my brother, I attempted to threat and dispose him. That prompted him to file the suit. And what relief he has claimed? That he is the exclusive tenant. The plaintiffs are the exclusive tenant since from their predecessor, Noor Muhammad. So, my lord, at the four corners of the plaint, your lordship has not even seen that a case has been made out that their grandfather was the original tenant, and thereafter tenancy has been flown, and by acts and conduct, by implied surrender can be presumed. Along with, my lord, I am not oblivious, along with the fact that his name alone takes place as, my lord, the in the rent receipt as one of the tenant.
Along with Maqbul shares.
Along with Maqbul heir, that is, my lord, Raitan is the wife of Maqbul. What is my, my lord, written statement? My lord kindly takes up. One paragraph I need to, my lord, read. My lord, page 12, your lordship kindly takes up my written statement. Yes, para 8. Before going to the paragraph-wise comment of the said plaint, this defendant states that one Kuplin Mirza, since deceased, the father of this defendant and also the father of the deceased Noor Muhammad, who is the husband of the plaintiff number 1 and the father of the plaintiff number 2 to 4 and pro forma defendant number such and such, and one Maqbul Mirza were the tenant in respect of the suit premises such and such, monthly rent of such and such. The said Kuplin Mirza, since deceased, started a partnership business of an eating shop with his nephew, that is Maqbul Mirza, in the year 1963. The said partnership deed was duly registered in the office of Sub-Registrar of Assurance at Calcutta, being book number such and such, such and such. Thereafter, the said Kuplin Mirza, since deceased, on 24th of May 1965, appointed his two sons, that is Noor Muhammad and the defendant. So, my lord, there, my lord, I was there as the defendant, as his constituted attorney, to act on behalf of his in the said partnership business along with Maqbul Mirza. Thereafter, the said Kuplin died intestate on 28th of November 1965, leaving behind his wife Zohra Bibi, his two sons, namely Noor Muhammad and the defendant, and one daughter, namely Ajmeran Khatun, as his legal heirs and successors according to the Mohammedan law to inherit his property. After mutual arrangement between the legal heirs of the Kuplin Mirza, that is his wife Zohra Bibi, his two sons, namely Noor Muhammad and the defendant, and one daughter, namely Ajmeran Khatun, some affidavits was done by the said deceased Nur Muhammad, and some letters was issued to the office of the Mutwali of the Board of Waqf, West Bengal, from which it is ascertained that all the legal heirs are the co-sharer of the business and co-tenants of the said premises, along with Maqbul Mirza, and only the convenience of the said business, the name of the deceased Nur Muhammad was used after mutual agreement between the legal heirs of the late Kopline Mirza. So on, the deceased Nur Muhammad and his legal heirs are not the absolute owner and the tenant of the suit premises. Moreover, the defendant is running the STD ISD business along with eating house business from the suit premises. This defendant annexed the said document gravely. So, my lord, it's a case for the first time in the defense came out, no, it is not the Nur Muhammad, but the father of the Nur Muhammad was the original tenant. And thereafter, the tenancy devolves upon all the heirs along with that Maqbul. And it was a mutual arrangement that was made that instead of recording all the heirs, Lord, I shall show before your lordship what is the contents of that affidavit and the letters written by Lord, the original tenant. That we all are the legal heirs of the original tenant, but we, for the purpose of convenience of running of the business, allowing you that your name should be incorporated in the rent receipts. But we all are in the business. And that was continued till Nur Muhammad was alive. Immediately after the death, within 1 month, the cause of action arises. And my lord, the circumstantial evidence documented it. It will come that yes, this arrangement was there. And all of us was running the business. Now, my lord, taking this clue, the plaintiff has not only failed to plead implied surrender in respect of the heirs, other heirs of the original tenant, but also in respect of the other joint tenant. When, on the contrary, from their record, it is the evidence from their side wherefrom it has been revealed that yes, original tenant was the grandfather of the plaintiff. Second, along with that, Lord Maqbul, and even after the death of the original father, the original tenant, the grandfather, the name of one of the heir, that is Nur, according to the mutual arrangement, his name took place in the rent receipts, and along with the Raitan Bibi, who is the wife of the Siddiq, wife
Maqbul,
of
Maqbul.
Maqbul. So, my lord, there is a second limb. So, he has to plead implied surrender in respect of at least the heirs of Maqbul. Otherwise, my lord, the suit is bad for non-joiner of necessary party because he is claiming tenancy right in respect of the entirety of the premises, which was given on rent. He has not made that observation is also there by the trial judge. So, no implied surrender pleading in respect of the other heirs, no pleading with respect to the other joint tenant, wherein, on the contrary, it has come to the record that even after the death of the original tenant, it is not only the Nur Muhammad whose name has been incorporated in the record of right, but also the Maqbul's heirs have been given. So there has to be an implied surrender from their end also. Now, my lord, taking this, kindly takes up, my lord, one portion of the evidence I will try, my learned friend has placed, kindly takes up page 41.
Yes.
This is the plaintiff's witness, my lord. Kindly see, I will take immediately to your lordship to the rent receipt now. I have filed rent receipts for the month of May 1965, when, my lord, the original tenant was alive. It was granted by the official Mutwali Board of Waqf. This document bears the signature of official Mutwali. This was issued in the name of Maqbul Mirza and Kopline Mirza. So it is within the knowledge of the plaintiff. It is came from their end itself that original rent receipts of 1965, when their grandfather was alive, that was in the name of Maqbul and Kopline. The document was lying in the custody of my father. Now, my lord, may I take your lordship, what was the document? In the paper book, my lord, it is kindly takes up once, my lord, page 99. It is the May 1965 rent receipt, my lord.
Yes.
Kindly takes up, my lord, the name of the work of estate is given and thereafter the name of tenant. It's Makbul Mirza and plus Kopline Mirza. It is from their end. So initial tenancy from their own document. Why the court has discarded his case? Because you started your case in the plaint from Nur Muhammad.
Yes.
Kindly turns over to page 100 also, same thing. Page 102. It's June 1965, same thing. Page 103. Now, thereafter, your lordship will found. Kindly takes up now in between page 100. So Kopline died in between. It's of May 1966, my lord. The in between, what happened between the heirs of my lord Kopline, I will show before your lordship. That is Exhibit D. So here your lordship will get after Kopline died, it is in the name of Makbul Mirza and Nur, the legal heirs of the plaintiff. So original one of the joint tenant took place after the death of Kopline. Now,
Your name never came up.
no. Why? I will place before your lordship why this has not been done. Now kindly takes up, my lord, page 105.
Nur and Raitan.
Yes. And it is of 1997. So, the creation of tenancy in the name of original tenants, both joint tenants, that was continuing at least up to 1997. So, no one apart from the plaintiff is running off business. Because this mutual arrangement was ad idem up to the death of Milord the Noor. Why? Now, Milord, Exhibit D has a very serious role. Because my learned friend says, Milord, he has denied the signature. His mere denial of signature, I have shown, Milord. That is the original affidavit. That has been, Milord, marked. The affidavit affirmed before the, Milord.
You have seen?
Yes, I have seen, Milord. Kindly, Milord. Kindly takes up, Milord, page 126. I will first rely upon this. Because this happens immediately after the death of the original tenant, Milord, Kopline. Death of Kopline was 28th of November 1965. Page 126, Milord, may I place? That my father Kopline Mirza died.
This is Exhibit D.
This is Exhibit D.
Achha.
That my father Kopline Mirza died on 28th of September 1965, leaving myself, Nur Muhammad, next Muhammad Siddiqui, Milord, their defendant. Ajmer.
All the years.
And yes, that my said father was co-tenant along with my cousin Makbul Mirza in respect of the rooms 2, 3, a kitchen, such and such, such and such. I'm not troubling you, Lord. Paragraph 3. That for convenience of business, my said brother Muhammad Siddiq, my sister such and such, and my mother have agreed to substitute my name in the said Sheresta of landlord, the said official Mutwali in place of my late father, the said Kopline Mirza, in exclusion of my said brother, sister, and mother, and for which I have supplied to the landlords the official mutwali on the foot of which my said brother, sister and mother have given their signatures and thumb impression in my presence. The said letter to the official mutwali has been made a part of the affidavit and has been marked A.
Which is 125.
My lord, I will, yes, which is 125.
All right. Yes.
No, my lord,
Not
no,
120.
not 125, thereafter.
Acha.
My lord, the 128.
No, this is not a letter. That speaks about a
Exhibit-
letter to the official Mutwali.
That is, my lord, the previous page. Letter to the
125.
official mutwali is 125.
Yes.
That though my said brother, sister, and mother will remain properties and co-sharers along with me in the rooms as aforesaid, only I shall legally remain co-tenant along with my cousin, the said Maqbul Mirza, in respect of the tenancies at such and such.
So therefore, he says this affidavit says that he will remain the co-tenant with Maqbul in
No.
exclusion of you.
No, not on exclusion.
He will
That
remain in
though my
possession.
said brother, sister, and mother will remain properties and co-sharers along with me.
Acha, acha.
So it is, my lord, for the purpose of a easy thing to be done. Instead of getting into names of all the heirs in the rent receipts, it is me whose name on behalf of others will given on the rent receipts. And my lord, coupled with this letter to the official Mitwali, my lord kindly takes up page 125.
125, yes.
5. My father, Koplain Mirza, who was joint tenants along with Maqbul Mirza, who died on 28 November 1965. After his death, by operation of Mohammedan law, the tenancy devolved upon me and my younger brothers, Muhammad Siddiqui, along with my sisters, my mother. For the purpose of convenience, they have decided that in place of my father, Koplain Mirza, the above mentioned tenancy should now stand in my name. In acknowledgement of the unanimous agreement, they too have signed this letter. In the aforesaid circumstances, this as a request to mutate in your record my name in place of my late father Koplain Mirza, along with the continuing joint tenancy Maqbul Mirza, who is my cousin. So, my lord, this as a whole proves, my lord, first, no case of implied surrender. On the contrary, documentary evidence has come before the court, including rent receipts, that there is no question of implied surrender. Had it been a case that I slept, Lord, it is a right that has been flown by operation of law.
Yes.
By conduct, it can be excluded, but conduct has to be pleaded, not pleaded. On the contrary, these documents are coming before the court. Now, my lord, my learned friend has stressed upon that as if my right evaporates since I have not exercised. After that, my lord, decision comes from the Waqf board. My lord, first of all, my learned friend has to show that what dispute is being canvassed before the Waqf board and why it has been relegated. Firstly, it is a tenancy dispute. My lord, tenancy dispute can be even not getting water. My lord, it is something which he has to prove. On the contrary, that yes, once upon a time I approached something, the board has relegated me to the civil court. I have not gone there. Though, my lord, not going there does not debate, as your lordships has felt, that it is something is coming as a defense of mine. I am not before the court. It is the plaintiff who has gone before the court, and he has to prove his own case. He has stated that it is the entire tenancy which he is now entitled to enjoy. So, my lord, this, in my respectful submission, is neither here nor there. Now, my lord, the document my learned friend is stated. So 1999 up to 1999, I have shown before your lordship that the other joint tenants, the other legal heir of the joint tenants are there as per rent receipts. So, my lord, what my learned friend has suggested, the corporation, the license department, the issuance of, my lord, enlistment, certificate of enlistment, and the electric bill and the, my lord, telephone bill does not have any bearing, because it is something which is flowing from 1965. So sometime in 2003-4,
If you are carrying business there, then why did you apply for trade license in only in the 2004 and 2005 and these?
No, my lord, it is my lord, some of the
bill.
documents which have been exhibited. It is not that, my lord, it is for the, my lord, it is not that. Again, my lord, I am repeating myself. It is the defense case. My lord, I am not proving anything before the court. He has to show his independent right.
You have said that
Even, my lord, your lordship kindly consider, even, my lord, for the sake of argument, there is a tenancy which has been inherited by the others. Until and unless there is a express or implied surrender.
109 Evidence Act.
Yes, one of the heirs' possession, even if, for the sake of, my lord, argument, I am saying I am not in physical possession over there. It's a co-sharer. One's co-sharer's possession is the possession of everyone. Until and unless he shows something contrary, either expressly or impliedly.
Alright.
Now, my lord, on the basis of this, the learned judge, my lord, I will not again, my lord, take your lordship to the entirety, but kindly takes up, my lord, this portion, whether this can be said to be a perverse finding. Because, or factually incorrect finding, my lord, taking into account all the materials available on record, documentary as well as the oral evidence. My lord, kindly takes up page 70, my learned friend placed. I shall place, my lord, page 71 onwards. Rather, my lord, page 70, your lordship kindly takes up this portion, this one paragraph, thereafter I take your lordship to 70. My lord, page 70, second paragraph. From the exhibited document filed on behalf of the plaintiffs, it appears that Maqbul and Kopline Mirza paid rents to the official Mutwali of the Waqf estate in the year 1965-1966 for the months of May. Exhibit 8 series also shows that the name of Nur Muhammad and Raitan Bibi have been shown in as tenants in respect of the suit premises. Exhibit 9, 10 and 11 shows that the rent was paid by Nur Muhammad in the year 2007 for the month of March to June, and also in the year 1999 for the month of May to August. It also appears from Exhibit 5 series that Nur Muhammad and Raitan Bibi paid rents to the Waqf estate for the some months in the year 1971. I have shown in 1999 also. So it is clear from the previously, the tenancy stood in the name of Kopline Mirza, Maqbul Mirza and Raitan Bibi also. But there is nothing in the plaint how the names of Raitan Bibi and Maqbul Mirza were excluded from the tenancy as tenants. Now, my lord, kindly takes up the documents which my learned friend, according to my learned friend, should not be relied upon. From the document of which marked as exhibits on behalf of the defendant, it appears that a license was issued by the KMC in the name of Nur Muhammad and Siddiq Mirza in the year 2004, which was valid up to 31st of March 2005. So Nur Muhammad, had it been a case that he is in exclusion of the other heirs in view of implied surrender, is my lord running the show, then it could have been otherwise. Exhibit A series further shows that the name of principal defendant has been shown as the licensee for running business in the suit premises in the year 2007, 2006, 2007, 7, 8, 8, 9. Exhibit B series also shows that the name of Kopline Mirza was recorded in running a business in the suit premises. It revealed from Exhibit C series that the name of the principal defendant has entered into telephone bills in the respect of the suit premises. It may be stated that the written statement that the defendant has taken a plea that his STD-ISD business along with pawn shop in a portion of the suit premises. It may further stated from Exhibit D series. It reveals that there were 4 tenancies in respect of 2, 3, 4 and kitchen set and also room number 13 at such and such. Nur Muhammad submitted the application to the official Mutwali stating inter alia that after the death of his father, Kopline Mirza, he, along with his younger brother, namely Muhammad Siddiqui, sister, such and mother, became the tenants by way of inheritance. But for the purpose of convenience to run the business, his name may be used for running the business in the said tenancy. Exhibit F also shows that the Kopline Mirza and Maqbul Mirza were the original tenants of the suit premises who executed the registered deed in the year 1965. It appears from the Exhibit E that said Kopline Mirza appointed his 2 sons, namely Nur Muhammad and Siddiq Mirza, as his constituted attorney for running the said business in the suit premises. It is curious enough that the plaintiff did not state the name of Kopline Mirza, Raitan, it should have been Raitan Khatun in the plaint, whose name appears in the rent receipts as well as in the documents as has been stated to be foregoing paragraphs. Apart from that, the documents which have been marked as exhibits on behalf of the defendants clearly shows that he was also running the business in a portion of the suit premises. It is also revealed that the defendants filed the documents filed by the parties that for the sake of convenience of running of business, some affidavits and letters were signed by the parties as well as the legal heirs of Kopla Mirza for issuing rent receipts in the name of Nur Muhammad. But it is also clear that the principal defendant was all along running the business in the suit premises. Now, Milord, kindly see in the next paragraph, page 73. In this context,
Yes.
it may be stated that PW1 at the time of his cross-examination could not say whether his grandfather, Kopla Mirza, used to run the business at premises number such and such. He has deposed that they have filed rent receipts to prove that the plaintiffs and pro forma defendants 2 to 4 are tenants in respect of the Waqf property, but no such document has been filed in the suit. PW2 such and such at the time of cross-examination has stated that exhibits 6 and 7 who do not stand in the name of his father. It has also been discussed that the two exhibits stands in the name of Maqbul and Kopla Mirza. So there is no such explanation or averment in the plain regarding the name of Maqbul Mirza or the said Kopla Mirza in those two rent receipts. It is needless to state that the plaintiff has pleaded all such vital facts in the plaint, and in absence of which it is difficult to understand how the name of Ratan Bibi and Maqbul Mirza was omitted from the rent receipts which were issued subsequently in the name of Nur Muhammad. So on the basis of this, Milord, the learned judge have dismissed his case. So there are two questions of serious pleading in the implied surrender, not pleaded in the plaint, rather suppressed. Why I say suppressed? Because it is within their knowledge, it is from their custody, the rent receipts have been exhibited. Now, Milord, whether these things, this, Milord, implied surrender is such a essential fact which needs to be pleaded in the plaint, or even the court can take an assumption or presumption from the document because he is coming up with rent receipts. So that may have disturbed your lordship's mind. So that's why, Milord, I want to rely upon a judgment of the division bench of this honorable court, Milord, reported in 2008 volume 3 CHN page 962. Here, Milord, Omoladitya and textile both has been taken care of because after textile, Milord, this judgment came. That's why, Milord, Omoladitya's principle, Milord, I am not, Milord, I know, Milord, that is page 962. Here it is a case of, Milord, eviction suit, wherein, Milord, the plaintiff is a subsequent purchaser.
Yes.
Who, Milord, sued the defendant Sholil, treating him to be the sole tenant. Sholil comes up and plead that it is not me because the last rent receipt shown Sholil's name. Defendant comes up and say it is not the Sholil, or rather the defendant who is the inducted as a tenant. It is his father, Shoshanko Shekhar, who was the original tenant. He died and thereafter tenancy devolves along with other brothers of Shoshanko. That was taken into consideration, wherein essentially the plaintiff started the case as if you are a tenant under me and it directly eviction suit. Kindly takes up paragraph 16. I will not disturb your lordship regarding the entirety. Milord, it is an observation of the honorable division bench.
Paragraph?
Paragraph 16, Milord, I'm sorry.
Yes.
We have already pointed out that when the added defendants were brought on record, the plaintiff did not amend his plaint. Here is also a case. Not did he add the third son of Shoshanko, but maintained the Sholil was the only tenant. In the plaint, there is no allegation that the prior to Sholil, his father was the tenant or that other heirs of the said father had surrendered the tenancy. The moment we find that the father of the Sholil was the original tenant and there is no plea of surrender taken by the plaintiff, it is necessarily follows that old tenancy is continuing. We have also found that the presence of DW2, the nephew of Sholil, the suit property has not been disputed, and it appears that Sholil's nephew is in actual possession of the property in addition to the heirs of Sholil. In the absence of any evidence given by the plaintiff or in absence of any amendment of the plaintiff by taking the plea of surrender of the original tenancy, we are unable to accept the contention of Mr. Chakraborty that the original tenancy after the death of Shashanku was impliedly surrendered by his other heirs than Sholil. The question of surrender, will not kindly mark this portion, whether express or implied, being essentially one of fact, must be pleaded specifically in the plaintiff. Otherwise, such plea cannot be permitted to be taken. In my respectful submission, this is such a plea which essentially needs to be pleaded in the plaintiff. In absence of that, what is my learned friend's contention? That forget about someone who is not coming before the court, so I did not made him a party. That is Makbul. And in absence of any implied surrender in respect of the heirs of the original tenant, he cannot maintain this suit. Another judgment, my lord, here is a case, my lord, where I lost. Instead of, my lord, showing this, it's my duty to point out before your lordship, because this is a subsequent judgment wherein I relied upon 2008. It is also a exactly said case wherein one person filed a suit for eviction who said, my lord, I am the original tenant. Original tenancy is in the name of joint tenancy of two brothers. One of the brother died. So if it is a joint tenancy, the survival brother is the sole tenant. I am a licensee under him. Suit filed. Defense was that, no, you are not the, you two brothers are not the joint tenant. It is original grandfather is the joint tenant. And thereafter, the document, as if here, the document came in that there was a partition took place in case of a tenancy also, tenancy rule, wherein lot C was allotted to my mother, the defendant's mother. So I take up the plea that no, and there also no implied surrender is being pleaded. But the learned trial judge will not dismiss his suit. They come up in appeal. In the appeal, my lord, I argued, my lord, relied upon 2008 judgment. But implied, taking into Kanji Manji's, my lord, implied surrender has been, my lord, theory has been applied, and I lost. My lord, this is, my lord, the judgment, wherein, my lord, your lordship will get, my lord, this Amarnath Pramanik judgment I relied upon. But subsequently, my lord, I citation 2008, oh sorry, 2020 volume 2 ICC, page 333.
If the SCC citation so that it will be easier for them.
2020 SCC online, Calcutta, page 3270. Lord, this judgment is assailed, Lord, by me, Lord, before the Honorable Supreme Court. Lord, this is the judgment, Lord, wherein, Lord, ultimately the suit got dismissed, holding that no implied surrender can be. It is one of the case, my lord, I face very rare. I argued for 20 minutes in while admission of special leave petition. The learned judges, my lord, allowed me to argue for 20 minutes. One of the rarest, my lord, example. But ultimately, my lord, the Honorable Supreme Court has set aside this. So, my lord, I say, my lord, this law is still prevailing. There is no departure on that. The original tenancy, in absence of any implied surrender, by acts and conduct. Last portion is not so relevant. 2G was tried to be argued, which has not been entertained by the Honorable Supreme Court. But the details of narration your lordship will get. That's why, I relied upon also, the division bench judgment. There your lordship will get the entire facts.
Can there be a partition in tenancy?
Lord, that is something that I say, I have not relied upon in that sense. So the parties, my lord, a documentary evidence came at least to show before the
You are
court.
forgetting the law, as you know.
My lord, no. Why, my lord, I'm saying, my lord, this, my lord, my lord,
I mean,
document
without
of
the
partition-
landlord granting a fresh tenancy,
No, my lord,
segregating
no,
between the two,
I agree, my lord. What I
your
tried to
property,
impress-
we are partitioning, we are the tenants.
No, my lord, what I
Tenancy
tried to
rights cannot
impress-
be.
what I tried to impress,
Yes.
on the contrary, at least a documentary evidence came wherein all parties have
But
signed.
this does not say anything regarding your proposition
Uh,
that implied surrender has to be there or something like that.
the implied
Supreme
surrender, my
Court-
lord, has been negated because the judgment has been settled. Sir, my lord, second page top, your lordship will get the, my lord, in view of the
speaks about the partition deed.
and thereafter in
view of the aforesaid
proposition,
position, that means
that
the position of the partition is accepted by the Supreme Court.
no, my lord, I'm saying the partition proves that the parties are acting in contravention of whatever the, my lord, appellant was suggested before the Honorable High Court, that the case of implied surrender. So there is an acts and deeds on behalf of all the heirs exercising their right of tenancy, at least to that extent, my lord. I'm not saying that legally that can be partition, but the act suggests that other heirs are interested on tenancy. So there is no question of implied surrender. I'm taking in that way, my lord. Not as a, my lord, partition, physically or legally, but the parties by their acts are suggesting that we are not giving away our right.
How does this help you in any way?
My lord, because here also the acts of the parties suggest, my lord, the documentary evidence came before the court that there cannot be any implied surrender because other heirs are suggesting that we are appointing you, that your name should be recorded in the rent
Yes,
receipt.
yes.
That's it.
Yes.
And my lord, the last but not the least, my lord, kindly see the schedule of the plaint as well as the rent receipts, also page 8. Because it is, after all, a tenancy right which needs to be declared.
Yes.
But I say, my lord, the schedule when it has been written hotel, and your lordship will get from the rent receipts also, everywhere it is hotel. So if it is a hotel, it is outside the scope of West Bengal Premises Tenancy Act, beyond the scope of the definition of premises.
Premises Tenancy Act
But even
56,
1956 and 1997, it is
56 excludes the hotel specifically.
both act, my lord.
I've forgotten.
Yes, my lord. Now it is
Show us-
2008.
Show us that.
Yes,
56 Act.
yes.
No, hotel vis-a-vis the resident of the hotel, I mean, yeah, the borders of the hotel, yes. But if both of us run the hotel, then
My lord, this is the definition of premises, my lord. 2F. My lord, the latter portion, 2F sub.
এটা কি আমাদের এখানে লাইব্রেরিতে ছিল? এটা বোধহয় প্রথম যে বইটা বেরিয়েছিল প্রথম প্রিন্টার। Yes. This must have antique value because this must be the first print which came out of the act.
My lord, sub.
And
Roman
includes-
clause 2, any furniture supply such and such, but does not include a room in a hotel or a lodging house. And my lord, kindly see the new act also, the same thing. So it is, my lord, something which
হোটেল যেটা বলছো, হ্যাঁ, হোটেল মানে ইটিং হাউস, নট দ্যাট লজিং ইটিং হাউস।
But my main thrash of argument is, my lord, with regard to that implied surrender. And in absence of that, and also, my lord, the suit is bad for non-joinder of necessary party.
But if a tenancy is given for the purpose of running a hotel,
It is outside the scope of West Bengal Premises Tenancy Act. So he cannot be said to be a tenant. His declaration, prayer A, is he is a tenant under work of estate. And Milord, your lordship, another interesting thing, the definition of
if-
hotel and lodging house has been separately described in 56 Act, which has been omitted in 1997 Act. So in my respectful submission, omission of that take into a broader, Milord, definition of hotel, because there a restricted meaning was given by giving a separate clause. This clause has been omitted in 1997. So I say, Milord, the intention of the legislature is to give a broader, Milord, definition of hotel. But this is, Milord, my supplement argument, not really touching to the merits, because this has not been argued,
A hotel room cannot be let out.
let out. That's why.
For the purpose of that, it cannot be premises. But
And Milord, if it is not the
once
premises,
it is let out, and then it is used as a hotel by the tenants.
then also, Milord, I say, but Milord, here the rent receipts bears that it's a hotel.
Hotel and a pawn shop and other things are also there.
But in the rent receipt, it is written hotel.
Over here is, my lord, it's a eating house, my lord, which is described as a hotel. In general term, my lord, if you go outside the, my lord,
Yes.
it's small eating house, my lord, they call it
There
as a
has to
hotel.
be an element of lodging in it. These hotels are,
These hotels are basically eating house.
we call restaurants hotels.
Restaurants only. My lord. That is what.
If I had have told my father that I have gone to a salon, he would have kicked me out of the house. What is a salon? You have become too stylish. So, like that, hotel restaurants were called hotels. Anyway, yes. So
This.
for whom? Board has nothing to do. You be a silent spectator.
I think, Milord,
No
board has-
question of that.
Board is a
Board has
performer defendant, my lord.
Board has
Board
not-
is a defendant, but
Board has not also filed any written statement, I believe.
I believe that.
No written statement from the board.
Oh, yes.
forget the board. Yes.
Oh, it is ex parte.
Ex parte against it.
Yes. Yes, Mr. Ahmed.
My lord, the judgment, my lord. My lord, with regard to the, my lord, implied surrender, my lord.
Implied surrender, yes, mostly.
My lord, the cases which has been referred, my lord, I believe those were the cases where the claim came from the side of the defendants against the landlord. This is a case where the defendant has already made a claim in the a claim for his tenancy right in the year 90, my lord.
Hmm.
And assuming that
But this is your suit. This plaintiff
This is
your
my suit. Well, assuming, my lord, the documents which has been, my lord, Exhibit D, which is the most relevant document, my lord, which was never admitted by me, my lord. It has been
No, he says your rent receipts show that other tenants were there.
certainly that is not the case. But since
So, but
since
you have not
after the, my lord,
pleaded implied surrender.
that was never the case because I was not being I never got disturbed from the side of the other tenant, my lord, from the side of the other co-tenant. They never disturbed me. They never created any issues with my tenancy. It was the defendant who came forward with the.
But you claim to be sole tenants. You have
But
not said so.
that was on the basis of the rent receipts of my father, of my predecessor in interest, which was being which was in the name, which was in his sole name since 1997.
So page 108 to 10110.
My lord. In the year 2008, all this disturbance started.
So the same logic as them. So the way they, because their names were not there as co-tenants,
Even if
therefore
even for the sake
they're
of
obliterated as co-tenants.
even if for the sake of argument I accept that the rent that my predecessor had given a letter to the official Mutawalli that this rent bill will be in my name for the family's convenience, then why did you approach the Waqf board in the year 1990 challenging that
I
rent
don't
bill?
know whether he challenged that deed or whatever he did.
Well,
What was the dispute before the Waqf board is
That
not
is-
before us. That is the point.
But still he has challenged the tenancy, that rent bill.
Very well. We'll close arguments on this.
My lord.
Heard learned counsel for the parties. Hearing is concluded and judgment is reserved in the matter.
I'm extremely.
I'm grateful. Thank you. এবার হচ্ছে ওই যেটা মেনশন করেছিল ওই ম্যাটারটা ডাকা হবে 7 না কত
জানলে ভালো হতো।
আচ্ছা আপনার ওটা কত
কারণ সব করে দিয়ে আপনি মান্ডের মধ্যে দিয়ে দিন আর এটা ছাপা বলতে
আর কি লাগবে কি
রেকর্ড করি আপনি কালকের মধ্যে বুঝতে পারবেন না আচ্ছা ঠিক আছে আপনি সোমবার দিন এবারে পাসওয়ার্ড না ওই মেনশন ম্যাটার ইয়েস
Item 9, I appear for the appellant. Lord, I'm being led by Mr. Anirudh Chatterjee. He's on his way. May I place my case?
মিস্টার
Anirudh Chatterjee, my lord. He's on his way, my lord. It's a refusal of an ex parte ad interim order, my lord.
ও ঘুরে ঘুরে বেড়াচ্ছে মামলা সৌনক ঠিক আছে ইয়েস
My lord, the brief background, my lord, there's a lot of documents. Perhaps the entirety need not be gone into at this stage. Brief facts, my lord. My clients were interested in purchasing or rather settling the, my lord, pending claims and cases in respect of two premises, 9 and 10 Pagladanga Road, my lord.
you are the plaintiff
I'm the plaintiff. I had filed a suit for specific performance of an unregistered MOU, by which, my lord, we were to acquire the rights, if any, of the defendants in respect of those two premises. 9
what
and 10
right
Pagladanga.
what sort of right
Yes, my lord, they have held certain leasehold rights and they had filed prior suits, my lord, by which they were claiming ownership rights also in respect of two premises. We had other deeds, my lord, that is not relevant perhaps at this stage because I am only seeking, my lord, injunction on the termination of the MOU, which has been subsisting for a substantial period of time. We have made part payment to these parties, my lord. The only reason on which the learned judge has turned down my prayer, my lord, is that the learned judge says there's a question as to whether the legal heirs of the original vendors under the MOU
1 minute
are
you are seeking specific performance of an MOU
of an
of
MOU.
MOU
Yes, my lord.
so what is the injunction you sought you said
My lord, injunction, my lord, will find the prayers at page 119. My lord, I am seeking an injunction upon the respondents, restraining them from acting in breach of the MOU, and, my lord, an injunction on the respondents from in any manner dealing with the scheduled properties, which form part of the MOU itself. They had terminated MOU of 2017, termination of 14 June 2025. My lord, I'm being led by Mr.
yes
Chatterjee.
Mr. Chatterjee, you can
The only ground is whether the agreement pilot is binding on the heirs or not. The learned judge says that I'm not sure if it's binding.
no you filed a suit for specific performance of those MOUs
Yes, my lord.
several MOUs
Yes, my lord.
No,
one MOU
Several
MOU
but those are litigations pending.
Acha, MOU that MOU was for transfer of shares of the defendants to
Yes.
you
Yes,
shares of their rights
rights.
the rights in the nature of
My lord, it would have been, my lord, ownership, could have been, my lord, lessee. Because there was a dispute whether they are owners or lessees, my lord, with respect to the entire property. So whatever rights they had, my lord, they
the
had to
right is
transfer.
indeterminate I mean
Right is, my lord, determinable.
Acha, very well.
Determinable. Either lease or, my lord, ownership. They had to transfer that. Now they agreed to transfer, they took money from me. Thereafter, my lord, they didn't get into those documents which they had to go through, my lord, in terms of, my lord, this agreement. So I did pay the rest of the money because I had to pay it, my lord, in terms of the agreement. The
Why was
judge
it- why was-
refuses it.
yes why
The ground, my lord. Sees the last page of the order. Top.
Page 520 starts. Page 523.
5 koto?
520 start. 523 is the
Your lordship may look into the memorandum of appeal
memorandum yes
and sees the last page of the order. By the time I opened, my lord, my instrument, your lordship would have read it.
your tab
Yes, my lord. I'm sorry. iPad. Very well. Yes. Thankfully, my lord, it's there, my lord, right at the. Your lordship has seen it, my lord. In this context, my lord, Kali got it.
yes
In this context, a very pertinent question comes whether the said memorandum of understanding dated such and such is legally binding against the legal.
let us read from the previous
My
paragraph
lord.
at the time of hearing
My lord. At the time of hearing, plaintiff filed photocopy of the said unregistered memorandum of understanding dated such and such, but it is pleaded by plaintiff that the defendants have cancelled said memorandum of understanding on the ground of delay by the plaintiffs by issuing a notice upon the plaintiff dated 14th of June 25. The said memorandum of understanding was alleged executed by and between defendant number 1. Below, there is no dispute as respect to the execution. and Srimati Anita Madan.
Anita
And-
Madan was your predecessor.
No, theirs. Because I entered into the agreement with one defendant number one and the predecessor of the other defendants. Anita Madan and plaintiff numbers 1 and 3, wherein a 2 years time period was mentioned for signing and executing the deed of conveyance. By the time of hearing, plaintiffs failed to produce any scrap of paper to show their willingness to perform. Lord, I have paid the money.
What proof of the money receipt was?
They have agreed to that. It's there in the cancellation document. It's there in the cancellation document. I'll show you, Lordship. Within 2 years from 9 to 2017, and all the registered deed of conveyance as filed by the plaintiffs are not connected with the subject matter of this suit, which is completely erroneous, but factually. Then this is where it is. The next paragraph. On this itself, the judgment should go. In this context, the very pertinent question comes whether the said memorandum is legally binding against the legal heirs of the said Anita Madan, since deceased, namely defendant numbers 2, 3, and 4. In memorandum of understanding dated such, there is no specific clause wherefrom it can be held that the memorandum of understanding creates a binding obligation upon the legal heirs in case of death. Because these are the heirs who have cancelled it. The cancellation.
Where's the cancellation deed?
Yes, kindly have a look at below. 607. I'm sorry, 507. And the important part below. I'm sorry. Cancellation document. Yeah, kindly sees below 14 June 2025. Cancellation letter is addressed by my clients Saranjit Singh, Rajveer Singh, Jasveer Singh, Tanveer Singh, and they are the heirs of late Anita Madan.
It is an unregistered.
Unregistered. Yes, yes. Now, NN Global has said that,
That is a different.
now there's no.
We are not on.
It is unregistered. They've accepted money on the basis of this.
Ad interim has been refused.
Refused.
Order 10. The present appeal has been preferred against the refusal of ad interim injunction in a suit filed by the plaintiff stroke appellants for specific performance of an agreement in the form of memorandum of understanding. Full stop, next para. The learned trial judge refused to grant ad interim injunction primarily on 2 counts. First, that there was no proof that the plaintiff stroke appellants were ready and willing to perform their part of the contract. And secondly, the agreement was not binding on the heirs and legal representatives of the original proposed transferor, that is the present defendants. Full stop, next para. We find from the letter dated June 14, 2025, annexed to the pleadings, which was a part of the documents before the learned trial judge, that by the same, the heirs of the original signatory, one Anita Madan, have purported to cancel the MOU in question, thereby admitting that the rights with regard to the said MOU, along with the associated liabilities, have devolved upon them on the demise of Anita Madan. In any event, it is right law that the heirs and successors of a signatory to an agreement are bound by the said agreement as well, unless such proposition is rebutted by cogent evidence otherwise. Next para. Insofar as the readiness and willingness component is concerned, even in the purported letter of cancellation, it has been admitted by the defendants that the plaintiff stroke appellants had paid an advance by way of earnest money of rupees 25 lakhs in terms of the agreement, comma, which the defendants stroke respondents seek now to return. Full stop. Such admission itself prima facie proves the readiness and willingness of the plaintiff stroke appellants to perform their part of the contract. Full stop. Next para. As such, comma, we find that on the materials before the learned trial judge, comma, which were the only determinants which could be looked at the ad interim expertise stage, comma, a clear prima facie case for grant of injunction has been made out by the appellants. Full stop. Also, comma, as per the pleadings in the injunction application in the trial court as well as this court, comma, sufficient urgency and the balance of convenience and inconvenience have been made out in favor of grant of injunction. Full stop. Next para. Furthermore, comma, in view of the purported attempt on the part of the defendants respondents to terminate the agreement in question, comma, the appellants might reasonably apprehend irreparable injury in the event injunction is not granted. Full stop. Accordingly, the defendants respondents are restrained by an order of injunction from dealing with the creating
Dealing with the Milord B, prayer B, if your lordship sees. That should be Milord,
Disposing or parting with possession.
Milord, it's page 20. Which is a copy, Milord, from the original injunction application, which is at 1122.
from
Oh, sorry, 119.
restraint from acting in breach of the MOU in question by dealing with, comma, disposing of, comma, alienating, comma, encumbering or parting with possession or creating any third party interest in respect of the subject matter of the said MOU. MOU gulo capse hobe. MOU dated February 9, 2017 till disposal of the application bearing Can 1 of 2025. Full stop. Next para, needless to say, comma, in view of the above observations, comma, questions of fact and law are involved, and accordingly, FMAT 260 of 2025 is admitted to be heard on the questions as on the grounds as taken in the memorandum of appeal. Full stop. Next para, the appellant shall file an affidavit of service on the next returnable date. Full stop. The application shall be listed for hearing on July 21, 2025, under the appropriate heading.
Grateful to you. The most important, Milord, thing in this matter is the address of the property, Milord, is 9 and 10 Pagladanga Road.
Suits you.
50 lakhs.
50 lakhs.
Milord, we have paid 50 lakhs and not 25.
আমি
25 to go.
দাঁড়া দিই না আর না পুরোটা হ্যাঁ এরা ওইভাবে ইউজ করছে এমওইউটা পুরোটা
I was being assisted by Mr. Shah. Milord, he's online. Ishan Shah.
yes give the names
We paid 50 lakhs and not 25.
to Mr. Ishan Saha
Milord, it's
not
been us-
25 50
50. It's been us for him, Milord. He doesn't.
সরি একটা জায়গায় 25 লাখ বলেছি ওই 25 লাখটা 50 লাখ no
He would give that in charity.
just ওই পেজটা একবার দিন 25 টা 50 করে দিন
50 crore.
দেখি একবার ফাইলটা
25 to two parties, Milord. That's why 25 each.
50 lakhs
Milord, for Mr. Shah, 50, Milord. He doesn't take such low amounts.
why are you maligning Mr. Shah he's not here
Not here.
yes yes come forward
Mine is 6.
oh yours is 6 then don't come forward
But 76 morning
Mr.
mentioned.
Krishnadas Poddar is waiting since morning
But 76 morning mentioned, my lord,
76
order 41. My lord asked, requested me, my lord couldn't reach by 3:30.
oh yes Mr. Poddar please wait
Please 3:30.
that's binding on you no if both parties are not present or Anyway, it's still not 330. We'll take up 76. 76 se call করুন। হ্যাঁ। 76, what is this?
Well, this is an order 41.
There is a caveat.
No, no caveat, but my lord, without caveat, on the last occasion, somebody appeared and sought for a copy. We have served him.
Mr. Chatterjee, we should not take it up out of town. We'll take it up on Monday.
So then kindly put that fairly at the top.
No, no, no.
Monthly-
Whatever you said in the morning, no. Remains in the list. Come back on Monday. Regular টাই দেখো 76 লাগবে না। No, Mr. Chair, not like this. এটা 5.
My lord, this is with regard to, my lord,
Yes.
dismissal of miscase under order 9 rule 13 on the ground of delay.
Ground of?
Ground of delay in filing the miscase under order 9 rule 13.
What was the delay?
Our defense was we had no knowledge, no notice and knowledge. My lord, nature of suit is, my lord, very curious, which, my lord, forbidden under order 21 rule 98, that no separate suit lies against the challenging the eviction decree.
It was filed.
Against the tenant.
It was filed during pendency of the execution case.
Yes, yes. It is the nature of the suit, my lord. And my lord, our main contention, main thrust is this: though we filed the miscellaneous case under order 9 rule 13, praying for setting aside of the ex parte decree obtained by the brother of the judgment debtor, but due to abundant precaution, we
Brother of the judgment debtor.
brother of the judgment debtor in my suit, in my landlord's suit. The present opposite part respondent is plaintiff before the court below is the brother of the judgment debtor, the regular tenant, against whom my father obtained an eviction decree.
That's a previous degree.
Yes,
Here
yes.
you are the judgment debtor.
Here I am the judgment debtor. And it was
Your father obtained a degree against his brother.
yes, who's the original tenant?
Right. Then that degree execution, an execution case
Wait,
was pending.
Execution case, my lord, execution case is over. In execution case, they maintain one section 47 application. That was dismissed. Against that, they preferred one revisional application on Article 227 before this honorable court. And in that court, my lord, they first time, my lord, divulged that their brother, his brother, obtained a decree in respect of the present suit. That is, knowledge came through the judgment debtor of my suit. And that's why when hearing this, we immediately filed miscellaneous case. And thereby we came to know it was the suit decreed sometime in September 2004. And that was, knowledge came to us when the civil divisional application against the dismissal of section 47 by our judgment debtor.
Understood, Mr. Poddar, but whether the suit was filed during pendency of the execution case, that is to be seen. Because if an execution case is pending, only then they can take resort to order 2190.
They also, after having this decree, they again second said they filed order 2197. First said the original judgment debtor. When all resort.
No, this suit which has been decreed ex parte, against which you have taken out order 913, this suit was filed at a time when any execution case was pending in connection with your suit.
In our execution case was pending.
So what was the delay in filing your order 913? We cannot enter into the merits right now.
My lord, may I start when last occasion we had
finished almost.
My lord, kindly then come, my lord, page 50.
You had placed the entire judgment 57. Up
No,
to
not
57.
entire judgment. It is
Up
not
to 57. It is underlined.
Yes. 51.
While you were reading, probably we had finished. Anyway, you can continue. What was the delay in taking out the order?
Delay near about 6 years.
Only.
So we at the very outset, not before your lordships, at the very outset in our section 5 application before the court below, we maintain it that due to abundant precaution, we are maintaining this section 5 because our knowledge is 2009. So according to us, the miscase under Order 9 Rule 13 is within time because 127 Article 127 of the Limitation Act. Well,
Limitation একটা দিন তো।
আগের দিন কোনটা দেখানো? 4 না না না।
One to three. 123.
To set aside a decree past ex parte or to rehear an appeal decreed or heard ex parte 30 days, the date of decree or where the summon or notice was not duly served when the applicant had knowledge of the decree. So we are on the second limb. So my lord,
You said you did not have knowledge. How
So
did you first came to know of the suit?
when 47 was dismissed?
Oh, that revision.
Yes, and against that, and the date of delivery of possession with the help of police is fixed. In the meanwhile, they preferred revisional application against that dismissal of section 47. In that revisional application in the High Court, they, my lord, they means our judge, my judgment data. First times he relied on that my brother obtained a decree, this decree can't be executable. That was the first knowledge. Otherwise, my lord, kindly see the nature of the suit. This sort of decree is not accruable on the person who is the brother of the judgment debtor. This is not a suit by the landlord.
But you had entered appearance in
that we have entered appearance. That is the $1 million question, whether we have at all entered appearance. First thing, my lord,
you had entered appearance, then the date of knowledge is
well,
not relevant.
we never say we entered appearance. It is their case. But before that,
records of the suit were before the court.
According to them, my father died while contesting the suit. There was no written statement. When my father died, they said we are substituted. Or after the substitution, it is as per provision of the law, someone to be served.
You took time on several occasions.
My lord, first summon, how it could be believed?
Without summon, you can know of the suit. There are many ways to know of a suit without summons. Is there any bar to entering appearance in a suit without getting summons?
When we are disputing that we had no knowledge.
You took time on several occasions for filing written statement. You appeared.
We did not take time because we had no knowledge.
Shouting would not help you, Mr. Poddar.
My lord,
you are not hard of hearing.
My lord,
the court's finding is that you took time on several occasions.
Irregularity takes place there, my lord. That was the event of 1991, allegedly, and my lord, decree was passed 2004. And the appellant before your lordships, he was examined before my lord sometime in my lord 2018. My lord, he was put question whether that you have entered appearance on 3 occasions, but there was no documentary proof that someone was served upon him. This is the issuance of summon and your endorsement of receipt. No such question was put. Only says that you entered appearance. Entering of appearance may be done through some other advocate by filing one application. There was no written statement, but what prompted us, we are the landlord, we obtain a decree, we are going to execute the same. what prompted us, having knowledge of the said suit, we abstain from proceeding in that, participating in that suit, and allowed the plaintiff to get the decree ex parte. It is, my lord, pure any ordinary man of prudence, it can be accepted, my lord. Now, when a decree has already obtained, and that is the barrier of the decree. The suit is the barrier of the decree. Now, what prompted us to allow them to obtain ex parte decree without contesting the same and seeking for time, 3-4 occasions, and prior to that there was nothing. Even no examination, no evidence adduced by the plaintiff opposite party in my miscellaneous case. No evidence, and not even any question was put. When I am disputing that I had no knowledge, it is the incumbent duty on the part of the opposite party plaintiff that to establish, my lord, that yes, you entered appearance. It is the acknowledgement that a summon was served, you received it.
Your ordinary rule 13 says it also appears from the record that during pendency, one Tapun Dotto learned advocate used to look after the suit on behalf of
Our suit, our eviction suit, that which was law instituted in 1969.
Let's come to page 4 of the paperwork. That it appears for the first time upon perusal of the said revisional application. That one Sudhir Bose as plaintiff initiated. 442 of 1980 is this suit, their suit, where they obtained this
Sudhir Kumar
ex parte degree.
for the first time. For the first
No.
time.
Then come to the next para after the prayers are set out. Come to page 5. Read it out, Mr. Poddar. That it also appears.
From the record that during the pendency of the above suit.
Above suit means that suit.
Above suit, one Tapon Dotto learned advocate used to look up.
Be a bit louder.
Above suit, our suit.
Be as loud as you were previously.
My lord, no. Once.
No, so that we can hear you at least.
Prevented, so I, my lord.
No, that is not necessary for you. But speak in your normal voice. This paragraph, just read out.
That it also appears from the record that during the pendency of the above suit means our suit.
No, above suit means their suit. Because in the same paragraph you stated that for the first time upon perusal of revision, you came to know of title suit 442 of 1980 against Pachu Sodai.
Not 89.
This is the suit where the ex parte degree was passed.
Also, that it also appears from the record appears from the record that during the pendency of the above suit, it is recorded version. It is not his personal knowledge. On Tapon Dotto learned used to look after the above suit on behalf of the defendant number 1.
Your predecessor was Pachu Sodai Datta.
Yes.
Pachu said.
It says it appears from the record.
Your predecessor had appeared on his behalf. There had been appearances.
It
obviously has to be from the records because your predecessor had.
Pachu Sodai Datta may appear, but we had no knowledge. But we are concerning about that what they are saying.
Your father entered appearance through an advocate.
And he died. He died.
Yes.
On the same year. In 1989.
But isn't this contrary to your submission that no summons was served? You were stepping into the shoes of Pachu Sodai. He was served, he entered appearance, asked for time to file written statement. And you come and say no summons was served.
We are saying that we had no knowledge. That means we had no summons. It is their contention that you appeared that 3 times and short adjournment. And that was allowed with cost. We don't know who pays cost. And my lord, it is the affairs of 1991. My lord, what prevented the opposite party respondent?
You don't stop there. Please read para 3.
That since the said Pachu Sodai said during his lifetime used to look after the said proceeding, your petitioner were not at all aware about the aforesaid proceedings. After the demise of the said Pachu Sodai said, the said learned advocate Mr. Tapon Dotto made contact with your petitioner and took some signature of your petitioners on some printed papers, which were represented to them that to be required for the purpose of proceeding pending before different courts. Different court means our proceeding, our arising out of eviction decree. As your petitioner hold the said learned advocate as the family friends, guardians and philosophers after the death of the said Pachu Sodai said, they put their signatures as aforesaid without raising any question and or explanation thereto. That unfortunately the said learned advocate, Mr. Tapan Datta, could not attend the court thereafter for his cancer disease and he died in 2007. None of your petitioner was aware about the aforesaid proceeding and whereabout thereof. However, here also we repeated that none of the petitioner were aware about the aforesaid proceedings and whereabout thereof. However, upon inquiry and searching the brief documents, records in the chamber of learned advocate by his main excepting some paper in connection with ejection suit number 892 of 1969, that is my father's suit. First appeal in connection thereto 142 of 1981. No more records in connection with any other matters proceeding suits were found, and as such your petitioner had no knowledge. We stress this, we had no knowledge about
Mr.
the-
Poddar, how can you say that no summons was served on you? Your father was the original defendant.
after substitution.
After substitution, after he died, advocate came, took your signatures on papers. You gave the signatures. You did not ask a question.
Yes.
He came to you. Suddenly he said, give signatures, and you put your signatures and did not ask any question. Why you were putting signatures?
My lord,
You're so naive.
my father contested the suit, my lord.
Then you knew your father contested the suit. In that connection, you were signing the papers.
Definitely.
What prevented you from taking information about the suit after signing the papers?
No, we have signed the papers, so many papers for the purpose of pending so many proceedings to empowering our advocate, that is my father's advocate, Tapan Kumar Datta, to contest all those proceedings. Because we never mind that there was against us, there was any suit like this. Otherwise, what was the reason for taking shy about the suit filed by the brother of the judgment debtor when we have a decree of eviction is in our hands and all sorts of application, including section 47, last resort of the judgment debtor, has my lord over. Well, kindly see the intention. If we had knowledge, what for? So, my lord, for very beginning,
You did not ask Mr. Tapan Datta why he was taking the signatures. For what matter?
my lord, since there are so many proceedings was pending because decree was not executed fully.
No, you did not ask him for which proceeding you are
That
taking
was,
this.
the
And you have not pleaded
he
that Mr.
maintained that since he was my old advocate of my father's advocate, he was a faint philosopher guy. We never put any question for what for.
If he was your friend, philosopher, guide, and if
What
there is an
kind of-
allegation of fraud against him, how can you impute that on him?
It is not.
Then
for-
if he was your friend, guardian and philosopher, as you say here, then he must have informed you about what the matter was about.
my lord, in answer
A
to
philosopher generally guides.
answer to your lordship's queries, if we had knowledge, we immediately rush to that court, and if we
Your friend, philosopher and guide, he duped you. He defrauded you.
he was suffering from cancer. He died ultimately in my lord during the
2007. Your
2007.
father died in 1989. He took signatures after that.
2004 degree.
From 1990 to 2007, 17 years he was alive.
Yes.
Tapan Datta was alive for 17 years.
Yes, and according to the respondent's case, that 91 or 3 dates we entered appearance and short time thereafter. What for this to obtain a ex parte decree from 91 to 2004? These 15 years there was no explanation. We are waiting.
We are also waiting for the explanation. We are also waiting. What is the explanation, Mr. Poddar?
Yes, explanation is if we had knowledge, we certainly took the steps prior to our suit, prior to the miscellaneous cases, execution proceeding, in the under execution proceeding.
Vigilante omnibus has rightly been applied by the trial.
And is another thing, which the
Only reason we are hearing you so long is Mr. Rai is appearing, so there must be something wrong in their case. So
My lord, now kindly see. Order
otherwise, Mr. Banerjee would be sufficient.
order
Yes.
15 Rule 27 which they filed, man. In
They filed an order for 2022
here.
to bring in what?
They are say they, my lord, annexed one judgment wherein their 47 application was disposed of, wherein the court found that this is a proceeding, my lord, which is, my lord, kindly see page 16 of the judgment.
Judgment.
That it's a collusive suit. All these things it is maintained.
In the
My lord,
divisional
the
court, divisional court's order.
Order number 270, my lord, kindly have page 16, passed on 23rd December 2024.
Page 16 of
They are
order for 2020.
yes.
And
Yes.
And my lord, in the meantime, my lord, they are one proceeding before rain controller, learned rain controller, claiming the same relief declaration that they are the pre-act subterranean that was dismissed on contest. We contest that proceeding. We contested that proceeding before learned rain controller. So, my lord, this is today's fix for passing order in this case. In this case, petitioner Devnarayan Basu and Gayatri Basu filed this present case under order 21 rule 97. This is the second limb of order 41, order 21 rule 97. Once maintained by our judgment data. Now it is against the opposite party petitioner's case. It is a case of the petitioner that they are third parties who are opposed to the execution of the decree passed in the original suit. According to them, their predecessor in interest, namely Sudhir Kumar Bose, was a pre-act tenant under one Mohitosh Bose.
You filed this order 2197? No, they filed.
They filed.
Obviously, yes.
we have filed in their execution proceedings. We have filed.
Yes. This was the section 47.
Order of 2097, which is only the subsequent orders passed in connection with the same.
Mohitosh Bose, in respect of one room attached veranda, one on the first floor of premises number 72/1.
You filed an order 21 rule 97 and also a suit.
The suit was filed prior to that.
Prior to execution.
Prior to execution, suit, but this execution was filed by not even
87.
97.
Suit of 80.
89.
Not 89.
89.
Then after execution case, as Mr. Pradesh.
The execution case started around 2003.
2003.
Page 16 at the top, my lord, you'll find the title execution case numbers.
That was a different execution case mentioned in. Oh, 442 of 1989 had an execution proceeding also.
Yes.
442 is the 1989 their case, their suit.
All right, very well.
Can you complete this?
So then, very well. No, then this suit was filed before the filing of the execution case.
Yes.
So where is the bar under order 21
After decree.
After decree, unless an execution case is pending, then one cannot come under order 21 rule 99 or 101. Order 21 rule 97 to 101 applies only if there is a pending execution case, not before, not after. Unless you have a different version of the code of civil procedure. Unless you have got a different version of the civil procedure.
Rejectment execution case 293 of 1987. What Mr. Rai submitted, that is not correct.
It is from here I am submitting. As you know,
21st November 1987, ejectment execution case 293, 98
That was the execution case of their suit.
They never, this suit was never see the light of execution. They never put the decree into execution. Just now your lordship's queries, the suit was filed prior to execution, so there is no scope to file the application under order 21/97. That's why suit is
So this
What?
87 execution case was
87 it is our execution case of
in respect of your eviction deed.
our decree.
So therefore,
Obtained against the original tenant.
so when they filed, then your argument becomes valid that 89 suit was barred.
Yes, for that is from very beginning I was saying kindly consider, my lord, the nature of the suit.
Can we enter into that whether if order 9 rule 13 comes in before that? That is a difficult. Order 9 rule 13 has been rejected. We cannot enter into the merits of that
Order
suit.
9 rule 13 rejected on the score of my lord, section 5. The delay was not condoned. Our contention was it was in time. It was for abundant precaution. We maintained that section 5 application because our knowledge is 2009.
Your knowledge is immaterial because you claim through your father, who was the original defendant. Your father was served summons, he was contesting the suit through one Tapan Dattu. Now, if your father was contesting the suit, after being substituted in his place, you cannot say summons of the suit was not served.
89 suit. My father also died 18 November. The number 448, 442. Number says it is after October or November.
We don't know the pressure of that court. We don't have any idea.
So my father, if my father got summoned, my father entered appearance, he must appear with written statement because this is a frivolous suit. This suit.
No, they can. Your father can
so-
appear, enter appearance by filing a vakalatnama. Ask for time to file written statement also.
My lord, our decree in our hand.
How do you know that? You yourself admit that there was a suit.
Kindly tally the behavior of that decree holder, letter decree holder, when proceeding before rain controller on the self-same relief, wherein we contested.
We understand what you are saying, Mr. Poddar. What could be the reason? We also don't know. But here the finding of the court is that from the records it is seen that 3 adjournments were paid by you for filing written statement.
Wherefrom he got
And you say, coupled with the admission that Tapan Datta, Mr. Tapan Datta, your friend philosopher guide, he could not have any reason to defraud you. If he was your friend philosopher guide, he could not have any reason to defraud you. So he took vokalat, they made you sign certain papers, obviously for the purpose of that suit.
My lord, may I once again, my lord, it is complete the judgment which I.
So this is their order for Rule 12.
Yes, yes.
Only if they press it, then.
But kindly see the judgment. Describe the nature of the suit. Whether suit is.
We cannot look into that unless the order 9 rule 13 is allowed. So if they press their order for Rule 27, we'll look into that.
No, they also say maintain in this application, but there is no use of disposing this suit. But kindly see the grounds, my lord. Paragraph 9 of their application that the instant facts, the documents herein are pertinent for adjudication of the lease, since the decree which the appellant herein are trying to execute has already been modified.
Mr. Yes, please continue.
Further, the contention of the applicants herein in the title suit number 442 of 1989 has already attained finality, and as such, setting aside of the decree under the provision of Order 9 Rule 13 of the Code of Civil Procedure would be a futile exercise. But I always try a judgment debtor who suffers an ex parte decree. He always tried to.
That is general logic.
Yes.
Otherwise,
Yes.
but in page 49, you in your evidence, Hiranmay Seth gave evidence for you, PW1,
Yes, yes.
who is petitioner number 2, appellant number 2 here.
Yes.
He said that you said that you could not recollect as to whether you had entered appearance in the suit.
Yes.
You do not deny that you entered appearance. You say you could not recollect whether you appeared in the suit.
It is.
And even as to whether you made any prayer for time to file written statement.
Yes,
If you
my lord,
go to the box and
90
say, I can't recollect, then there is no denial.
I can't recollect means that not that he is accepting the contention. It is, well, kindly see.
It's not a question of accepting, it's your application. You have to deny. At least you have to go to the box and say that no, we had not entered appearance, we had not been substituted, and we had not filed any written statement. You have to deny. It's not a question of your acceptance. You have to deny. In your evidence, you don't deny. You say, I cannot recollect. If you cannot recollect, how can you deny? How can you deny something which you can't recollect? Only if I recollect that, yes, this is Mr. Poddar, I recollect him. Only then I can deny that the other person is not Mr. Poddar. One who does not recollect what happened cannot deny or affirm. It's your case in Order 9/13 to deny. If you can't deny, then you don't substantiate. Your witness fails to substantiate your Order 9/13 case, Mr. Poddar. Why blame it on Mr. Tapan Dutt alone?
My lord, kindly come to page 25. This is the deposition.
Yes.
From 26, that during the pendency of the aforesaid execution case, an application under section 47 of the CPC was filed. The said
Chief won't do, Mr. Poddar, please come to your cross-examination. Please come to page 33. You cannot remember anything. Please start from the first line.
I have not furnished any letter of authority or power of attorney.
This we are ignoring. You need not
I
have a.
can't state if we were substituted as defendant. Number 1, A to C. I can't state if we are substituted as
You
defendant.
cannot say state whether you were substituted. You don't deny that you were. You don't say that I did not substitute. I was not substituted. You say I cannot state if we were substituted. You might have been substituted.
Language is different.
No, definitely not. Denial is something else from not knowing. Yes, then
said suit or otherwise. I can't state if we had entered appearance in the said suit. I can't also state if any prayer for time to file written statement was preferred through our learned counsel.
Brilliant.
Said suit on 26 March 1992. It is also not within my knowledge. Here it is not within my knowledge, but in prior sentences he says it is. We can't state straightway denial.
What denial? You cannot state me does not mean you deny at all. Does not mean you deny at all. You say I cannot state whether we entered appearance does not mean we did not enter appearance. And next, let us see.
It is also not within my knowledge if that prayer was allowed subject to payment of cost was of rupees 16. It is also not within my knowledge if another prayer for time was made on 15 May 1992 and the same was also allowed subject to payment of cost of rupees 32 or otherwise. It is also it is not also within my knowledge if similar prayer on 16 July 1992 was again allowed subject to payment of cost of rupees 48. I can't state if similar prayer made on our behalf on 5th September 1992 was rejected or otherwise. My father had appointed Sri Tapan Dutt, learned advocate, to defend the suit. I can't recollect if any power was issued by ourselves in favor of learned advocate after the death of our father.
So you know that your father had appointed Tapan Dutt to defend the suit? If you knew your father had appointed Mr. Tapan Dutt to defend the suit, you knew about the suit?
This is after 2009. It is after 2009. I can't recollect if any power was issued by ourselves in favor of learned advocate after death of our father.
You cannot recollect even that, whether you executed any power. And you are a graduate.
With reference to the contents of paragraph 4 of my affidavit in evidence, I am to state that we put our respective signature on some court papers under the instruction of our learned advocates. Such signatures were obtained after the demise of our father. Title suit 892 of 1969, which was brought by our father, was looked after originally by our father, even till his death. Subsequently, after his death, we, the petitioner, used to look after the same under the instruction of our said learned advocate. I can't state if I had to put my signature on any application or affidavit in connection with the affidavit of the said suit. I have practically no knowledge regarding the affairs of title suit 892 of 1969. While I did not also depose in the said suit, it is our suit. It is also not possible for me to state if the said suit was even transferred to the Court of Presidency Small Cause Court from the city civil court or otherwise. So far I have heard the said suit was decreed in our favor. I can't state any detail if any execution proceeding was preferred on the basis of such decree. It may be fact that the said decree was put into execution on our behalf. It may be fact that the title execution case 176 of 2003 might have been preferred on the basis of such decree, and the same was transferred to Presidency Small Cause Court, Calcutta. It is a fact that I have deposed in the said execution proceeding. It is a fact that decree was passed in one suit, but I can't state as to which of the two suits the same was passed. But
Read the next sentence.
he's so innocent about the court's business. Everything he is saying, I don't know. Whether he decree obtained by your father, I don't know. I had no known.
Very innocent.
When otherwise one can't trap on this sort of suit, and decree, eviction decree is halted.
His innocence is proved in the next sentence all the more. Please read out.
When the learned advocate, Mr. Tapan Datta, obtained our signature on some printed papers, we might have also executed the Vokalatnama in his favor. This is naturally Vokalatnama to be executed to join the suit.
You said you did not know what paper you were signing.
Huh?
You say your order 9 rule 13 case is that you did not know what papers you were signing.
We might have. It is a fact that the original eviction suit brought by my father was ejection suit number 892 1969.
In this case, might is right.
My mother and my brother were substituted in his place in the ejectment suit 892 1969. This is assertive.
Only this.
It is a fact that the suit being 892 1969 was actually a suit for ejectment, not a title suit. And accordingly, what I had disclosed in my cross-examination on 18 January 2014, describing the suit to be a title suit is not correct. The same should have been ejectment suit 892 of 1969. It is a fact that the said ejectment suit was decreed in our favor. It is also a fact that the relative execution proceeding arising out proceeding arising out of the said ejectment suit ejectment execution case 293 of 1987. My lord, kindly see 1987.
Go on reading. There are several Easter eggs waiting for you.
It is a fact that our said learned advocate counsel, Mr. Tapan Datta, was all along conducting the progress of both ejectment suit and the execution proceedings. It is a fact that the learned advocate, Mr. Tapan Datta, who was conducting the said ejectment suit and ejectment execution proceeding on our behalf, and the said learned advocate, Mr. Tapan Datta, who entered appearance on our behalf in title 8 suit 442 of 1989, was same and identical person. Tapan Datta is same. It is not that.
It is a fact that learned advocate Tapan Datta, who was conducting the ejectment suit and ejectment execution proceeding on our behalf, and the said learned advocate Mr. Tapan Datta, who entered appearance on our behalf in title suit number 442 of 1989, was same and identical person.
Question was the Tapan Datta learned advocate who represented your father in 442 or 1989.
Not father. Not father. Who entered appearance on our behalf.
No. Question. Answer to the question. What was the probable question from the plaintiff?
Might have been a suggestive question.
Yes. This is not so injurious. Tapan Datta, who entered appearance on our behalf, title suit 4 was same and identical person. Not a fact. My statement to the effect that Mr. Tapan Datta did not disclose before us about the affairs of the fate of the said 442 1989 is incorrect. If there was anything, any knowledge,
This is double negative, goes in your favor. Don't worry about this.
I can't state whether our several application for time to file written statement was considered, and ultimately after rejection of the last such prayer, we did not take any interest in the said suit.
This is suggestive question. We are ignoring.
What a fact, it was within our knowledge that the said title suit such and such was decreed against us, whereby we are debarred to execute the ejectment decree passed in ejectment suit number 892 of 1969. It's a legal question. How can you say? It is a fact that Sri Mohitos Bose and Sri Sudhir Kumar Bose were full brothers of each other. It is a fact. However, it is not within my knowledge if they resided in the same address or not. It is a fact that I had deposed in Miss Case 291 of 2006 before Presidency Small Cause Court, Calcutta. I can't recollect if I had deposed in the said proceeding that the family of Sudhir was also.
There is nothing interesting, nothing more interesting. The interesting part is over.
What is over?
Why did you choose him as your witness?
I don't know who choose it.
Mr. Tapan Datta was also not there at that point of time. Your friend philosopher guide, some other friend philosopher guide probably. Would not have been you, Audio Learned Junior. Would not have been you, Audio Learned Junior, that is very obvious. But you have demolished your case brick by brick in your evidence.
If that be so,
Whatever little damage was left to be done in the Order 9 Rule 13 application itself, your witness has gone and done that much also. How can we salvage this for you, Mr. Poddar? 6 years delay. We fully appreciate you saying what you are saying. That a landlord, someone who is enjoying an eviction degree, why should he not contest? And particularly since it's barred apparently by Order 2200.
that was held by the learned court below on their application.
It's obvious.
If it is the nature of suit, if it is in such type of suit, mischievous, frivolous suit.
But since Mr. Rai is appearing, let us see whether
Yes,
we can take a lenient view.
that is
Let us see him defend his own.
separate
That is one point in your favor.
for his honor.
Let us hear him, Mr.
My-
Poddar. You have done your level best. What else can we do? Yes, Mr. Rai. Why shouldn't we take a lenient view? Section 6, High Court. We are over glorified. We are the topmost court of the state. So.
I'm talking about my lord's observation in the delivered by my lord's judgment.
No. Those observations were for Mr. Poddar. Our observations will be entirely different for you.
So, my lord, what is the case made out? He has no knowledge about the proceedings during the suit.
They handed over papers to their friend philosopher guide, Mr. Tapan Datta.
Order sheet.
And they don't know what happened after that.
And this is the series of order my lord I have annexed where the time was sought for on their behalf to file written statement. And none of the orders has been challenged in either way.
What do the orders say? I mean,
The defendants, now, first is defendant number 2 filed their separate petitions for time.
these are the order sheet. These are the order sheets
Yes,
of your suit, of the suit which was repeat expert.
yes.
Your order for 2027.
No. These are part of the records.
Part of the records.
Yes, but LCR is not here. That's why I obtained the entire order sheet of this process.
These are certified copies of
Yes.
the.
Some markings are there, my lord. Forgive me, my lord.
Give Mr. Poddar a copy also.
I also give. চারটে বেজে গেছে তো তাহলে জেরক্স করে নিয়ে আসি পরে দিয়ে দেবো
Only one copy for us.
my lord I'll give
Defendants 1 and 2 are the original defendants.
1A and 1 and 2 my lord. Subsequently there are চারটে কপি আছে
Your tagged pages. Tagging যেগুলো রয়েছে সেগুলো। Substitution এর পর দেখি ওরকম।
এই যে না কই এই কপিগুলো কই ডিপেন্ডেন্ট যেটা ওটা না ওইটার মতো বাঞ্চ জেরক্স করে আছে
When did their predecessor die? Mr. Poddar, when did your predecessor?
November 1989.
89
Just 1 month, within 1 month of institute of a suit. With this time, Sir, within 1 month of filing of the suit.
Up-to-date service.
একটু সেপারেট কপি আছে আমি দিচ্ছি পদার্থ এটা দিন এটা দুই দর্শককে দিন পদার্থ দিন তাহলেই হয়ে যাবে But I prepared a small copy where the dates have been mentioned, which is reflected from the order itself. May I get back? First order, my lord, 26/3/1992.
Give a copy to Mr. Poddar also.
Yes, yes, I have had it.
What are these?
These are the order date, my lord, your lordship, find precisely the order date where the adjournment sought for filing statement cost imposed, because those are the questions which was put in the register. From where your lordship find?
Yes, one ABC.
One ABC, my lord, got it. Cost of rupees 16. One pair of the different number 1A, A and 1B by.
This was done by Mr. Tapan Datto, their friend philosopher guide. They did not know. That is Mr. Poddar's case.
Now, my lord, can consider.
And that is corroborated by his evidence.
Evidence.
No, corroborated that he does not recollect because he did not appear. And he did not know, as Mr. Poddar suggests.
The evidence of the prosecution, my lord, itself is clear that he has knowledge about the suit. That portion I want to draw your lordship's attention. After that, my lord.
That might be dependent on the structure of your question also.
No, my lord, if that be so, my lord, I could have understood. My lord, if your lordship can consider the.
The question is that is Mr. Tapan Datto who appeared on your behalf in your eviction suit the same Mr. Tapan Datto who appeared on your behalf in the other suit?
If the eviction suit, then I do not know whether the eviction suit I do not have any
Said
knowledge.
no.
No.
In all other questions, he has said I don't know.
And here he specifically said, yes, on our behalf in that suit.
If you had such a witness for the other side, Mr. Rai, you would not need any advocate in the court. Some cases it happens. If you have someone as the advocate in the other side, you don't require to argue also. He wins the case for you.
In this case,
It always happens.
Tapan Datta, who was conducting the said ejectment suit, and ejectment is our behalf, and the said London Tapan Datta.
Whether your evidence has demolished your case.
After this, my lord, corroborated by the order, sees the water passed in the proceedings.
Even if you are appearing, we are unable to do anything for Mr. Poddar. No, someone of your stature, that is what we are saying. You are appearing, let us explain ourselves for the camera, because we are now playing to the camera nowadays.
No, camera is closed.
Nothing is closed. In our court, camera is always on. We don't hide anything.
No. What?
Your camera, your
monitor closed.
Monitor may be closed.
Yes.
We are saying this, Mr. Rai, because you are an eminent advocate. An advocate of your stature is appearing in a matter, leading him, who is also quite competent, itself shows that there may be some lacuna in your case.
Don't put this.
That is why we said that because you are appearing, there may be something in their case. That is the reason why we said. Now we have given explanation.
At least one ordinary rule
That was our presumption.
But ordinary rule 13 before this court, my lord, section 5, it is something. And I am involved by my lord's judgment. If your lordship wants, I can.
Judgment.
I cannot lose.
No, what is the proposition there?
That your lordship, the case made out that I have no knowledge about this proceeding. Subsequently, it appears that orders have been there where they are recording their presence. So the entire foundations regarding ordinary rule 13 was bad. So
No judgment is required.
you can only for that, only that. And my lord was also quite that Poshumati Super Reddy was considering both the judgments.
You don't consider
No,
any
not
judgment. This is sufficient. Yes, Mr. Poddar, any reply? Should bring your witness for the reply. Your witness should come and give the reply.
Reply regarding this certified copy of the trial court record.
You're denying that also.
I don't know who it is. Not the.
We'll keep it on record. You file a 340. Now, what is the current counterpart of 340 now? BNS.
Heavily relied on these 4 orders. I don't know who filed application. Who filed application?
You have not made out any case, either in your pleading or in your evidence that there was a fraud practice upon you. Somebody impersonated you, and
That
rather you said you handed over signed documents.
some prohibitory word, some gentlemen did not use in the court of law. But
Some
the
gentlemen.
other word he says that we had no knowledge, we can't recollect, and the background behind his conduct, what is the nature of the suit? Why he allowed the plaintiff to have the expert degree? That is sufficient.
No, Mr. Poddar. We are passing our judgment.
Yes.
Dismiss করেছি. The present appeal has been preferred against the dismissal of an application for condonation of delay in preferring an application under Order 9 Rule 13 of the Code of Civil Procedure filed by the present appellants and the consequential dismissal of the application under Order 9 Rule 13 itself. So next para, the premise of the application under Order 9 Rule 13 of the Code of Civil Procedure and the connected condonation application was that the present petitioners, who are the heirs and legal representatives of one Pachu Shodoy Set, ACTH, while appearing in a revisional case in connection with an application under Section 47 of the Code of Civil Procedure filed by the judgment debtor in a suit for eviction where a decree was obtained by the said Pachu Shodoy Set, for the first time came to know about title suit number 442 of 1980, which had been instituted apparently by the present respondents, whose predecessor in interest was the brother of the judgment debtor in the eviction suit of the appellants, eviction suit of Pachu Shodoy. Next para. The learned trial judge, upon hearing parties, disbelieved the case upon adverting to the evidence of PW1, the sole witness for the appellant. Next para, learned counsel appearing for the appellant submits that the suit itself, that is title suit number 442 of 1980, in which the ex parte degree was passed, was not maintainable in view of the same being in contravention of the provisions of Order 21 Rules 97 to 103 of the Code of Civil Procedure. Next para, it is submitted that the said suit was filed during pendency of an execution case filed in respect of the eviction decree obtained by the predecessor in interest of the present appellants, late Pachu Shodoy, in respect of the self-same property. Next para, however, learned counsel further submits, the appellants were entirely unaware of the said suit, that is title suit number 442 of 1980, one Mr. Topon Dotto, an advocate who was representing the said Pachu Shodoy in several litigations and was like a friend, philosopher and guide of the appellant's family, had obtained certain signatures of the appellants in and on papers, without indicating as to the purpose for which those signatures were obtained, after the demise of Pachu Shodoy. Next para, as such, it is submitted that there is nothing on record to attribute knowledge of the suit, which was decreed ex parte, to the present appellants. Next para, learned counsel appearing for the respondents submits that respondent submits, by handing over photocopies of certified copies of the order sheet of the concerned suit bearing title suit number 442. It is 442 of 1989.
442 of 1980 and one place
80 or 89.
Your Lordship, please.
সব জায়গায় 80 করে
80,
গেছে,
that's right.
there's a misprint in there, Order 9 Rule 13. We have been following that. সব জায়গায় 89 হবে
89.
89 and submits that on several dates comma adjournments were sought on behalf of the present appellants in the said suit. Full stop. Next para. It is further submitted that PW1 comma in his cross examination comma pleaded ignorance in respect of all the relevant facts. Full stop. However, comma conspicuously it was admitted that Mr. Tapon Dotto was a learned advocate who had appeared on behalf of the appellants and conducted both the ejectment suit and ejectment execution proceeding on behalf of the appellants, as well as entered appearance in title suit number 449 of 1989. Full stop. Thus, comma, it is argued that the very premise of the application under Order 9 Rule 13 of the Code of Civil Procedure was demolished by the appellant's witness, by the respondent's, by the appellant's witness, as well as the order sheet of title suit number 442 of 1989, which clearly goes on to show that the appellants had entered appearance on several occasions in the said suit after being substituted in place of Panchu Shoday, comma, the original defendant therein. Full stop. Next para. Upon a careful perusal of the materials, comma, we find that throughout his cross-examination, comma, PW1, comma, who was the sole witness for the appellants in support of the application under Section 5 of the Limitation Act and Order 9 Rule 13 of the Code of Civil Procedure, comma, he feigned ignorance, F-E-I-G-N-E-D, feigned ignorance about the suit bearing title suit number 442 of 1989. Full stop. The said witness went so far as to state in his cross-examination that he could not recollect whether any power was issued by them in favor of the learned advocate Mr. Tapon Dotto to defend the said suit on the death of their father and or whether the appellants were substituted as defendant numbers 1 within bracket small a to 1 within bracket small c in the said suit or otherwise. Full stop. He further stated in his cross-examination that he could not say whether the appellants had entered appearance in the said suit or whether any prayer for time to file written statement was preferred through their learned counsel in the said suit on March 26, 1992. Full stop. He further could not say, comma, as per his evidence, comma, as to whether similar prayers were for time were made on May 15, 1992, comma, July 16, 1992, or September 5, 1992. Full stop. Next para. Thus, comma, the PW1 very conveniently and selectively feigned loss of memory in respect of the relevant features of the concerned suit. Full stop. It is to be noted that there is no specific denial in the cross-examination to the suggestions put in that regard by the present respondents, comma, as discussed above. Full stop. Nowhere in his cross-examination does the PW1 deny that the appellants had not entered appearance in title suit number 442 of 1989 after being substituted in place and stead of their deceased father, comma, who was the original defendant, and or that they had sought for time to file written statement on several occasions in the said suit. Full stop. Rather, comma, the PW1 admitted in his cross-examination that Mr. Topon Dotto obtained the signatures of the appellants on some printed papers, and that the appellants within double inverted might have also executed wakalatnama in his favor. Double inverted close. Full stop. Next para. What clinches the issue against the appellants further is the admission of PW1 in his cross-examination that it is a fact that learned advocate Mr. Topon Dotto, who was conducting the ejectment suit and ejectment execution proceeding on behalf of the appellants, and the said learned advocate Mr. Topon Dotto, who entered appearance on behalf of the appellants in title suit number 442 of 1989, was same and identical person. Full stop. Although learned counsel appearing for the appellant before us seeks to argue that the said answer may have been given to a cleverly framed suggestive question on behalf of the plaintiff stroke present respondents, we are unable to agree with the same. Full stop. Even if a suggestive question connecting the appearance of the self-same Mr. Topon Dotto in both the proceedings was put to the witness, it was always open to PW1 to merely deny such suggestion by stating that he did not know whether the Topon Dotto who appeared in title suit number 442 of 1989 and the one who appeared in the ejectment suit of the appellants was the self-same person. Full stop. On the contrary, PW1 admitted that the advocate appearing in both the matters was the self-same person. Full stop. Next para. We must also take note of the fact that within the four corners of the application under Order 9 Rule 13 or the evidence of the appellants, nothing has been stated, nothing has been alleged against Mr. Topon Dotto advocate, who admittedly took signatures of the appellants on printed papers, which might have been used as vakalatnama in the suit in question. Full stop. Next para. Rather, Mr. Topon Dotto has been described as the friend, philosopher, and guide of the appellants and their family. Full stop. Thus, there could not have been any premise in the pleadings or the case of the appellants to the effect that the appellants were defrauded by Mr. Topon Dotto advocate, who had entered appearance in title suit number 442 of 1989 on behalf of the appellants. Full stop. In the absence of any such allegation, it cannot be denied that it is the appellants who consciously executed vakalatnama in favor of Mr. Topon Dotto, who had entered appearance on behalf of the appellants in the said suit bearing title suit number 442 of 1989 on several occasions, as borne out by the order sheet of the suit itself. Full stop. The order sheet of the suit cannot lie, but the appellants may. Full stop. In the circumstances of the case and the evidence of PW1, read in conjunction with the facets of the case as discussed above, we are of the opinion that the overwhelming majority of the evidence on record indicates unerringly towards the appellants having been utterly negligent in pursuing their remedy by filing the application under Order 9 Rule 13 of the Code of Civil Procedure about 6 years after the passing of the ex parte decree in title suit number 442 of 1989. In such view of the matter, there is no scope of interference with the impugned judgment and order. Full stop. Next para. Accordingly, FMAT 93 of 2022 is allowed on contest against the against the respondents,
is allowing.
Dismissed on contest, thereby affirming the judgment and or order and order না and করে দিন এটা and order dated December 22, 2021, passed by the learned judge, 8th bench City Civil Court at Calcutta in miscellaneous case number 329 of 2010, arising out of title suit number 442 of 1989. Full stop. There'll be no address to cost.
Grateful to Lordship.
Thank আচ্ছা can গুলো যেগুলো আছে pending,
We are not pressing order for order.
can such and such are only can 3 is pending.
Yes, yes.
Can 3 of 2025 is disposed of in the light of the above judgment. Full stop. Interim order, if any, stands vacated.
Grateful to Lordship. আরেকটা হলে বুঝতে পারি না। ঠিক আছে।